For motion item number 1.
Yes, Mr. Moore.
Motion. For the appointment order of the respondent number 3.
Let us see the order. Which page?
Page number 23, Lord.
Page number 23.
Or go find the type copy at page number 24.
Okay, just read. What is this post? Voluntary
Yes, Lord.
voluntary worker.
Grade 4 post.
This is Srimati Wodangbeni.
Lord.
She is a R4.
Lord.
This one R3. But what is your case? Why are you aggrieved?
It's that also. The petitioner being an educated and employed projects made it an application for consideration. There was no selection process. It was appointed without any selection process in violation of the constitutional mandate.
Okay.
Second, we have also contended that I'm also a landowner.
Third, Mr. Muajamir, learned counsel for the petitioner. The petitioner. Stop. The petitioner is aggrieved by the order dated 14/8/2024, appointing the respondent number 3 to the post voluntary worker at Bandari CHC under the establishment of the Chief Medical Officer Wakha. Chief Medical Officer Wakha. Where is your application?
Page number 20.
It is the case of the petitioner that petitioner is he or she? He being an educated and unemployed had applied for the said post on 28/6/2024. However, the state respondents, without considering the application submitted by the petitioner, has appointed the respondent number 3 to the post in question without adhering to any selection process. Stop. Secondly, it is contended that the petitioner is a landowner who has a right to be considered for appointment to the post in question. Stop. Issue notice to the respondents, to the respondents returnable after 4 weeks. MS S. Chung accepts notice on behalf of the state respondent number 1 and 2. Therefore, no formal notice need be issued to the state respondents. Stop. The learned counsel for the petitioner shall, however, serve the requisite copies of the writ petition to the learned state counsel within
In the course of
in the course of the day. Stop. Insofar as the respondent number 3 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of 2 days from today. Okay.
For admission, item numbers 2 to 4.
Mr. Roshi,
Yes.
I filed the affidavit in reply in respect to the position paper, the state respondents 1 to 6 as well as the regularization respondent 7. And all the trade petitions this morning.
This morning.
Would you kindly list this matter for hearing after 2 weeks watching?
Okay. Affidavit in reply. Only this morning,
This morning.
Mr. Subhamwati. Mr. Subhamwati Wali,
Roshi,
the learned counsel for the petitioner submits that he has filed the affidavit in reply to the affidavit in opposition filed by the state respondents. Filed by all the respondents only this morning. Stop, only this morning. The affidavit is however not on record. Registry to trace the same and place it on record, listed after 2 weeks.
Question.
For admission, item number 5.
Yes, yes, yes.
And representing all the state respondents.
Okay, okay.
Petitioner is asking for regularization of preserving 32 years. Now, I have sent this program for waiting. For waiting. So, it is very form of after 2 weeks.
Okay. Yes, Mr.
So it's
Mohan.
noting the same submission was made on the last occasion.
Ah,
On 1990. Portion due to the vacation. It has not reached me.
okay.
Okay,
Okay, let them, I think they have a very good excuse. So vacation is a good excuse. So, okay, okay. Mr. Moimchan, the learned senior government advocate, submits that the affidavit which has been sent for the vetting of the department is still awaited, and therefore 6 for 2 weeks time. Prayer is allowed, listed after 2 weeks.
For admission, item number 6.
Yes,
You're also. And for the
they're also vetting. Yes, Mr. Mohan.
It is, my friend is seeking for hearings, so I'm limited. And I'm expecting the instructions, maybe the worksheet. Who would be granted? Last occasion was a motion.
But this is for payment of a placement error.
Yes, ma'am. Similarly situated person have also been granted so your lordship.
Pay them, finish the case.
Yes. With the instruction from the department as to why that's been delayed or delayed.
Okay. Heard Mr. Joshua Shaki, the learned counsel for the petitioner, and Mr. Moimchan, the learned senior government advocate for the state respondents. Stop. The learned senior government advocate shall on the next date place the instructions as to why the placement errors due to the petitioner has not been paid as of date. And the reasons thereof. We'll give a direction that there shall be no further adjournment.
Also, allow me to open this. Lord, even if it is not a written affidavit, even
Yes.
a written instruction will also be sufficient. Lordship, last occasion was a motion.
It's all right, it's all right. But considering that
Application was also there.
I think this order was passed on 12/9. So I think it's high time you get instructions, not necessary for this affidavit as the learned counsel for the petitioner is submitting. Just place the instruction as to why it is not paid and as to when it can be paid.
Right.
Correct. So we give you how much time? Okay, please. Okay. Listed after 2 weeks. Okay, yes.
For hearing item number 7 to 9.
I will to leave. What is the matter about, ma'am?
Lordship, I hear the petitioners are seeking for scale pay as well as the regularization from the service.
Regularization, we don't know, but I think if you're discharging the same works and duties as discharged by regular employees, you should get it. I think the appeal which the state went before the Supreme Court is also dismissed. Do you have a copy of that order?
No.
This is 2020. Okay. Tell Miss Abitoli to be ready on the next day. MS S. Subong Chang makes a mention on behalf of MS AIME, Learned Government Advocate, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Stop. It is made clear that no further adjournment shall be granted, and any adjournment sought shall be subject to post payable by the learned counsel for the petition or the state respondent.
For hearing item numbers 10 to 12.
Yes, what is this?
Hello, it's a question pertaining to the passing of the order passed by the Lokayukta.
Yeah.
Here, the impugn order 19/12/28 has been under challenge, whereby the Lokayukta has passed a order in direction to the Deputy Commissioner to take action against the petitioner.
What action?
To cancel the land documents which has been issued by the respondents, that is the Deputy Commissioner.
Mr. TV, what is the case? Whether actually Lok Ayukta, what is your stand on? So far as Lok Ayukta is concerned?
The lordship, this where the lordship may pass an order to take this case along with other matters of lordship. Here the order is regarding the part of the on the two parts.
Okay.
One part relates to writing of government ruling, government parties, PWD parties. And the second part relates to illegal regulation of the. Now, the issue involved here in this issue relates to the second part, illegal regulation of the land quarter, over which those government quarters are standing. With the community market.
What about the first portion?
Now,
Writing off?
writing off that part, that is a case where a clear direction has been given by the local writer to the different township to cancel the right of.
The order writing of the building.
Yes. So when the matter that is repetition adjudicated, or when these matters were setting up, this repetition has been separated because in this case, what is local authority being commented for verification by the inquiry, and based on the recommendation, the deputy commissioner has issued a short order. No final order has been passed as yet. No positive direction has been passed. Look, deputy commissioner has already issued a short order. That is understandable. But in that first part, local has given a direction. So that I consider yes. Local can only make recommendation, not direction. So in on that ground, that no direction can be given by the person, that order was says. Now, the second part, so far as the second part is concerned, it is only a recommendation made, and no final decision has been taken as on date. GSC has only issued a short notice as to why the regularization of the partner should not be missed. And that short notice. For the as for submission, in fact, like relief is still premature. As on date, no right to petition. And 226 is for enforcement of legal right to petition. As on date, no legally to have the petition.
Why don't you approach the DC? Who knows DC may pass an order in your favor?
The petitioner can take that same law before the DC, reply to the short notice, and then DC pass some appropriate order, final order. And if petitioner is agree, they can always process now report. The deputy is always.
Yes, because what I understand is that this court has already quashed the order passed by the Lok Ayukta directing the deputy commissioner
So far as that first part is concerned. Writing off.
to cancel the order writing off the building.
My little friend has given the submission to the extent of write-off. My case, I don't know how my case is been club up, even with the write-up as well as the random with the issue of land pattern or regularization of land pattern. My part is involved in this order in both ways. One way, they are saying that my house has been issued with the write-up. But building. Other way, in the article of part 2, even my name has been reflected. So it will be effective. So in the
I didn't get you.
here, the Upayukta, the June order, that is 2019, it was in two parts. One is the write-up, the other one is the irregular issue of pattern. Regularization of land extension and mutation of the Pata in PWD colony by the office of the Devotee Commissioner. So this was the finding given by the Lokayukta. So my name has been listed in the write-up also, and on the second part.
But right up the Learned Council has conceded.
That's why.
Conceded.
Now, to that extent, it's okay. But if we go through the contents of the findings of the Lokayukta, the learned court below, if your honor kindly turn to page 73 of the
Just give me the gist.
Before any recommendation is met for available relevant notification office memorandum of the state government in regards to the land allotment and produced below for reference of the authorities which shall be directed to be taken action. So after this, the Lokayukta has given a reference of the Government of Nagaland Land Revenue Department notification dated that February 1992. Then he has referred LR 2/2/21/88 dated 10 November 1993. Notification LR 2/21/88.
Okay, Lok Ayukta, basing on this notifications office memorandum, Lok Ayukta has made a recommendation.
No, he has ordered cancellation. Thereafter, after following all this, in the last paragraph of this particular order, it is referred to there. I mean, we are allowed to read out. After referring all those notifications issued by the government of Nagaland from time to time, it was against the government servant or the state employees. That is the bureaucrats who issued the irregular or allowed regularization of land parcel extension report, what it was settlement order. It was to be taken action against the government officials. Now, but not against the petitioner, my lord.
Why?
Because I've not committed any lapses in this case. And the
You are the beneficiary of the wrong committed by the officials. If it is proved, of course.
yes,
If it is proved,
yes,
you are the beneficiary.
I'm the beneficiary, but my fact, the case hearing is little bit different from what
Okay.
it is coming up before the honorable court. If the court permit, I'm including the facts.
So I'm just trying to get the gist. After that, I will use.
So it is very clear at page number 73, before giving any recommendation, that is the observation.
Yes, just wait. Before giving any recommendation, what is your case?
So he has made a reference to the notification.
Okay.
Then at page 75. Thus.
What is the operative portion of the order?
Yes, can you be allowed to read this portion so that the court will come to understand?
Uh,
Thus, all the land allotment without the prior approval of the government by various administrative officer in Timapur has violated standing government orders. And in fact, the office memorandum dated 10/11/93 that all allotment of government land made by the private individuals irregularly or in violation of the ban number GAP 2/6/7 dated 15/12/1992 shall stand cancelled with effect from 1st January 1992. The statement given by the officer who has issued the allotment order of plot and other related orders at BWD Colony Timawar is that they have not allowed any plot of land in which there is a standing government quarter entered for any kinds of order issued by the DC office Timawar is in regard to plot of land where there is standing government quarter should immediately be cancelled. That is the order.
that is the quarter.
Yes.
Or along with the land.
Land and everything.
Mr. TB, whether actually Lok Ayukta can directly issue an order giving a direction to the deputy commissioner to cancel.
No.
Recommendation, you are right.
That is how the sentence starts, before making any reform.
Okay, let us see the impugn order.
Yes.
Let us see the impugn order.
Impure order is the portion that I read out is at 75.
Page 75.
Yes.
Yes, just wait.
Recommendation to him.
75.
Recommendation to cancel should be immediately cancelled.
No, this is 75. You are referring to 75. This is the notification.
No. After the board has made a reference to the notifications. If we read from the last.
Let me just go through the Lok Ayukta's order.
Yes, my lord. So Lokayukta order starts from page 57.
Page 57.
Yes. Connected to the department. May I read?
Yes, wait.
The Nagali Lokayukta Kohima case number RC 2/2030 before Srimaya Honorable Lokayukta order 19/12/2019 part 1 Ramban condemnation and dismantling of BWD waters in Timapur. This case is originated from the letter dated 24/9/2013 received from the Under Secretary to the Government of Nagaland Department of Work and Housing Branch, requiring the then state vigilance now required that to inquire into the matter of rampant damnation in dismantling of PWD department.
Okay, Mr. Benna. You as such, you are not aggrieved by the order passed by the Lok Ayukt.
I'm saying.
No. You are not questioning the jurisdiction of the Lok Ayukt.
I'm challenging that.
Jurisdiction. You are challenging the jurisdiction also.
Yes, ma'am.
Okay.
To inquire into the matter of rampant condemnation in dismantling of PWD.
But I think, is it not too belated to question the jurisdiction of Lok Ayukta? Because actually this complaint was registered in the year 2013, before the vigilance.
I know, here, this particular order 2019 was passed. When the main case was already been decided, it was by the court below. And it was reopened by this order, where I've been aggrieved.
24/9/2013.
19. Here, yes, there was a complaint 24/9/2013. That
That-
was a complaint, which was registered as RC case number 2 of 2013. And this case RC 2 of 2013 has already been disposed of by the lower court below,
By which court?
by State Vigilance Commission. If you order, you can make a reference, page 59, my lord. This order, this disposed order reserved dated 12 October 2018. So it was disposed by this particular order. RC 2 of 2013, which was registered against the complainant facing on 24/9/2013 has already been disposed of. Then, when the criminal case was already disposed of, the Lokayukta, by passing this 19/12/2019, has reopened the case, my lord. And when he reopened the case, I've been affected adversely.
If you are a wrongdoer, you will be affected.
That will decide later on.
Yes.
But whether Lokayukta has the power to reopen the closed chapter, a closed case, that is one issue.
But the case decided by the vigilance was a criminal case.
Yes, criminal case. And in that criminal case, the accused has been acquitted.
It's all right. Accused is acquitted.
Yes. So we are not.
But what about the civil consequence?
Civil consequence, the only Lokayukta can take action for on that aspect, because Lokayukta is mostly confined to PCA and PCA. Then it has to conduct trial against the person who has been involved in that case. Here in this complaint, my name is never.
No, I think it will not conduct cases.
Then,
Am I right? It is only an inquiry. Yes.
then instead of, after completing of the inquiry, instead of making a recommendation to the state government, why he has passed only and give a.
That is exactly what I want, whether this is a recommendation or whether this is an order cancelling your regularization.
Yes, so.
If it is an order cancelling your regularization, that I think the Learned Council has fairly admitted. But if it is a recommendation, then I think, the Deputy Commissioner Dimapur says of the matter, then this is premature. So I want to know whether the order passed by Lok Ayukta is a final order or it is only recommendatory in nature. That is exactly what I want to understand.
As if it is a final order, then the whole question of issuing charges for this, that's what I asked.
No, here, my lord, he have committed the lapses. Was directed to cancel my land matter, but the Deputy Commissioner issued a shoe post notice to me. Issue a shoe post to me, so that I have.
Let us see. Let us read that order.
Yes.
Yes.
The most operative part it will be, if you are maybe, and you turn up to page 75.
75.
Yes,
The operative portion.
yes.
70.
After the notification, ST Lalthara chief
Ha.
secretary. Not 75, 73 will start from 73.
73.
Just from below the table. Yes, that
Let
I
us-
was giving a reference.
ha.
Because from here, just below the table. Yes, before any completion, that was which I've been referring to the.
73 from which portion?
That chart.
Illegal regularization.
Yes. Immediately after that, there is part two. Part two, your worship, starts from. Part two starts from 61, page 61.
Okay, let us read the whole order. Let us see. Let me understand.
Yes, yes.
Let me understand. That's starts from page 57. Correct. So let us read.
Shall I begin from the beginning?
Yes, you can.
Yes. Part one, government condemnation and dismantling our
Okay.
PWD quarters at Timako. This case has originated from a letter dated 24/9/2013 received from the Undersecretary to the Government of Nagaland, Department of Work and Housing Branch, requiring the then State Vigilance Commission, now Lohayukta, to inquire into the matter of government condemnation and dismantling of PWD Department quarter in PWD colony Timako. Accordingly, an FIR was registered against engineer Keshitu, now this is STU Housing Tree Timako and other under section 4094/21 IPC. During the course of the investigation, the Nagaland Lohayukta police led by Srimati Purumi SP in her investigation then established that late engineer Kashitu STU PWD Housing Timako issued 45 numbers of write-up survey report against PWD quarter at Timako and engineer Kakuli, the then PWD Housing had approved the following 42 numbers of survey report for write-up of the PWD quarter. So the table has serial number 1 to 42. In my
Yes.
hand is reflected at serial number 21.
21.
Yes, 21. This act of write-out quarter at
Yes,
Timako.
yes. So your PWD quarter number is PWD 127.
Yes.
Okay. Yes, this act of
This act to write out PWD quarters in Timako by the then SPU H Housing Tree and EA Housing Timako was in total contravention of number 1. The notification finding condemnation / write-up of government building issued on 9/11/2009 by CAPWD Housing, followed by another notification on 26/3/2010. There is another notification issued by the state government on 29/2013, which is reproduced here and below. Government of Nagaland Work and Housing Department, Housing Branch notification, dated Kohima 20th September 2013. Number so and so. The governor of Nagaland is pleased to order that the practice of condemnation in write-up of the government building with a view to allotting the site to some individual or society, etc., shall be banned with immediate effect. However, for the purpose of reconstruction or construction of the new government building in the same site, the department concerned are allowed to dismantle the old building and seek post facto concurrence of finance department for writing out the value of the dismantled building. It is reiterated that no site of any government building or government land can be allotted or given away to any individual or group or organization till further orders. This issue with the approval of the cabinet conveyed by office memorandum number so and so. Number 2.
this is continuation of the notification.
I don't know how the learned court below has come up with all this. Number 2. Establish procedure which is under The survey report for condemnation of building are to be approved by the
Okay.
chief engineer with the housing with no objection certificate from the user department and forward to the deputy commissioner of the respective district who are the chairman of the condemnation board. The condemnation board on proper verification recommends and forward to the government for obtaining necessary approval in right of sanction for the building which are beyond economical repair. The depreciated value of the building as per the survey report are then deposited to the government through treasury challan. The depreciated value is for building only and that empty plot land is not the part of the condemnation, my lord.
Okay.
Number three.
This is the observation.
Yes, these are the observation. That is what I could make out. Otherwise,
Yes, yes.
number three, in the instant case, the depreciated value work out of the 10 STUH housing tree and approved by the 10 EA housing demobber was collected by issuing receipt and not by deposit to the government. Based on the established facts and circumstances as above, the Directorate of Vigilance in Anti-Corruption filed charge sheet against ER Gauhati and then ER Gauhati, the then EA Dimapur under Section 409 IPC, read with 13 Clause 1C, Section 13 Clause 2 of the PCA Act 1988. The Honorable Court of the Special Judge Vigilance in TTV Kohima by judgment in order dated 31/1/2019 acquitted accused Engineer Gauhati Sima from the liability of the case. The operative part of the court order is reduced herein below. Order. In view of the aforesaid facts and circumstances, the prosecution has failed to prove the charges for the offense punishable under Section 409 IPC, read with Section 13 Clause 1C and 2 PCA Act 1988 against the accused person, namely Srimati Engineer Gauhati Sima. The then accused is hereby acquitted from the liability of the offense labeled cancer. In the meantime, the accused shall execute the bill bond of rupees 1 lakh with surety of the like amount who shall be the government servant serving within the jurisdiction of this court. The accused shall be required to appear before this before the higher court in the event as when such court issue notice in respect of any appeal or petition filed against this judgment. The bill bond shall be enforced for a period of 6 months. The registry is now the registry is to draw and the bond as provided at form number 45 of the Code of Criminal Procedure and execute the bond accordingly. The judgment and order is pronounced in my open court and in the presence of the parties. Given under my hand and seal of this court, I have signed and delivered the judgment on this the 30th January 2019. This disposed order reserved dated 12 October 2018. Kuldu Kusu Special Judge Vigilance Commission. Mere perusal of the Honorable Court order dated 31/2019 reveals that the Department of Work and Housing of the state government has not been precluded from taking suitable action to recover the loss caused to the government by the two officers named above. Accordingly, the PWD
Let's read once again, mere perusal.
Yes. Mere perusal of the Honorable Court's order dated 31/2019 reveals that the Department of Work and Housing Housing branch of the state government has not been precluded from taking suitable action to recover the loss caused to the government by the two officers named above.
Two officers name above means
Gauhati.
Engineer Gauhati and Heshto.
Yes.
Okay. Okay.
Yes. Accordingly, the Department of Work and Housing branch is hereby directed to, this is direction, Your Honor, verify the building yet to be dismantled by the allottees out of 42 write-off building mentioned above and cancel the dismantle order issued by the then STUH 3 and EAH Dimapur. So that is one order, direction.
Is hereby directed to verify the building. To verify the building yet to be dismantled by the LOT.
And to cancel.
Mr. TB. From what we are seeing, I think it's a clear direction that maybe the Lok Ayukta may not have that power.
Yes, so far as the part one is concerned. So that has been
Right up.
interfered with.
So you are.
I considered in 208, I have the
Two
copy,
ju-
I have copy of the judgment,
Okay, 208.
208,
So this is part one.
part one,
This is
Write off.
writing off the building.
writing of the building. And it does not include land condemnation. I considered, Your Worship. I have copy of the judgment, Your Worship.
Yes, okay. Okay, yes.
Yes. Rework out the depreciated value of the building already dismantled and ensure deposit of the amount through challenge to the government. Write to the Deputy Commissioner Dimapur to cancel pata or allotment order issued against the empty plot / land of the dismantled PWD building. Verify and identify the allottees of the condemned building and those serving PWD officers / employees and serving government servant of the other department who has connived to get the allotment order of the dismantled building and land in their name or their deeds and can be punished as per the rules of the government. Verify the remaining PWD standing quarters in PWD colony Dimapur by a team of senior officials from Work and Housing Department, Housing Branch, along with the Deputy Commissioner Dimapur or his representative, ROTC Office Dimapur and LRSO Dimapur to determine the number of standing PWD building at PWD colony Dimapur, encroachment, illegal occupation, etc., and to find way to stop unauthorized dismantling of PWD quarters and allotment of the emptied land in future. A copy of this order be sent to the Commissioner and Secretary Work and Housing Department for action. A copy of the judgment in order dated 31/2019 passed by the Honorable Court of the Special Judge Vigilance in DTP, Kohima will also be included for the reference to the department, of the department. Action taken report shall be submitted to the IG and Director, Nagaland Lokayukta, organization by the department on or before 30 days from the date of this order.
90 days.
Yes, my lord, I'm so sorry. 90 days. 90 days. Part 2.
This is part 2.
Now it's, yes,
Oh,
part 2. It's coming to part 2. My lord.
yes. Just wait.
Yes.
Part 2. Okay.
Irregular issue of pata, regularization of land extension in mutation of pata and PWD colony Dimapur by the office of the Deputy Commissioner Dimapur. During the verification of the occupants of the PWD quarter in Pata holder of the land with the standing PWD quarter in PWD colony Timabur. It was established by the Lokayukta police investigation team that each of the PWD quarter occupant were in possession of either regularization order, settlement order, extension order, rectification order, mutation order, Chamapanti, Pata book, and other orders. Each of them claimed that the land was allotted from the Deputy Commissioner Office, Dimapur. They also stated that the Pata were issued against the standing government quarter. As such, the land belonged to them and not the PWD department. And on scrutiny of the documents received from the occupants of the PWD quarters at PWD colony Dimapur, it was found that below mentioned 65 files were used to issue regularization/extension order by the Deputy Commissioner Office. So the chart is prepared, my lord, and my name is reflected at serial number 29. The file number.
What about the other allottees?
Other allottees, my lord, to that extent, some are which has been filed and with the other batch of writ petition. Some are included here, some may not be included here. That, but
you are concerned only for one petitioner, only one single petitioner in this writ petition.
Yes, in this is writ petition 113 is concerned with Mr. Pendangman.
Okay.
And I've other two.
But the documents are more or less the same. On which
Yes, my lord.
Okay.
Yes,
Okay.
more or less the
Continue.
same. So my file is referred to at serial number 29.
Yes.
Yes. File, 10 files were requisitioned from the Deputy Commissioner Office. Out of 65 files mentioned, herein mentioned, above mentioned, the TC Timabur Office could furnish only 6 files. That is number 1, Revenue 2/93D, number 2, Revenue -7/2002-D, number 3, Revenue -4/87D, Brigade 4, Revenue 4, serial number 4, Revenue 4/87-8/PT 5, Revenue 5/79-D/PT. Number 6, Revenue 8/2008-D. Thus, the status of the remaining 59 missing file is not made known.
Why this pick and choose?
No, I'm sorry. I said the status.
No, the status of the remaining 59 missing file is not made known to the investigating team by the state office.
Yes,
why is the deputy commissioner choosy?
I don't know how that has been done. I'm not aware because honestly, I'm submitting this to the court. When the criminal case arising out of the complaint dated 24/9/2013 was arised against the 2 officials, my land documents was insisted by the investigating agency, basing on which we have handed over the land document to the investigating agency. Accordingly, they have issued a seizure memo
Yes,
to that
Mr.
extent.
Dijimomi. Why is the government selective? You see page 61. So much of revenue files, 61, 65.
Lordship.
Only 6 were handed over. Why selective?
Lordship, here it has been mentioned at point number 6, that the remaining 59 missing file is not made known to the
That's why that is the question raised by this court.
Lordship. To that, I have to take a necessary instruction. Until and unless I get a necessary instruction, I'm unable to make.
Yes, Mr. TB, something is wrong.
And that is the only file which were furnished to a local, your lordship, to the
And
investigation.
my lord, if not mistaken, this honorable court has directed the vigilance to submit a case report also. From there, we can make that out. And if the state cannot prove all this, I'm saying that I've been adversely.
The state has been directed to produce these records.
Yes. Lower case record, LCR case record, which was taken up before the trial court. So I believe there should be some reason why it has not been put up. But how comes the Lokayukta come to this consideration that out of this much file, only certain 6 file has been detected. And out of 6 files, I'm one of the person aggrieved by passing this order. Why not to the others 59 files?
Mr. TV, something is wrong here.
Your Lordship, whatever files were handed over to the investigation team, based on that, the investigation was conducted. So for as regards the remaining files, Your Lordship, even in the order it is stated these are missing, it was not furnished to the investigation team. That is a problem. And
Why,
supposing.
why is the office of the deputy commissioner being selective? Out of 65 records, only 6 were submitted.
Lordship.
And on the basis of the submission made by the deputy commissioner, the Lok Ayuktha has either recommended or directed cancellation. See, you cannot actually like allow some of the LOTs to escape the law and allow the others to be prosecuted.
But we are only concerned about the petitioner lordship on the last occasion.
It's not about the petitioner.
Lordship,
The court is concerned about the action of the state government.
lordship.
It's not the petitioner. This is a case filed by the petitioner.
Lordship.
But why only pick and choose the petitioner?
Lordship.
Allow others to occupy the alleged encroached land?
That I,
Then for the petitioner,
lordship.
anyway, we'll hear him. Maybe we'll leave it parted and we'll direct you to produce all these records, which is in page 61. We'll direct you to produce.
Lordship, on the last occasion by this honorable court order dated 4/7/2024, lordship. This honorable court has directed.
And if all these 61 records are produced, we direct the Lok Ayuktha also to initiate action against the 61 also. Everybody should be treated equally.
Correct.
Provided we find that the Lok Ayuktha has the power to do so. Okay.
Yes.
Yes.
So in this page number 62 of my read petition, the particular portion that we have been referring, my name, my file, mutation file, my lord, is serial number 19. M-418/12/447-48. This pertains to me, my lord.
Page.
Page 62 of my read petition, the one that we have been making a reference. It's serial number 19 in the table. Right. So M-418/12/447-448 is my mutation case number. I've mutated the land from the earlier landowners, and the entire procedure has accordingly followed by observing all necessary procedures. And the pata was issued in my favor by the deputy commissioner. So that is one aspect that I'm just trying to justify. Then I may be allowed to read out the low portion of the judgment. During investigation, only 2 case record out of 54 case record were found. Your Honor, this is also very important. During investigation, only 2 case records out of 54 records were found. That is file number M507/508/12/14650-51 dated 30/10/2012 and M-949/12/4580-81 dated 7/11/2012.
What is your file number?
Here,
418.
yes, 411.
During the investigation, only 2 case record out of the 54 records were found. What is
Yes.
that?
That means, my lord, what I could able to observe is in this table, he has made 54 mutation cases from serial number 1 to 54, my lord. One left side is from serial number 1 to 27, the right side is from
Then 61 is regarding what? 61 is pages,
60
65 is what?
yes, 461, they have made a reference from serial number 1 to 65. They have 3 column has been made out.
Huh. So this is, this 61 is,
The missing concerning with the file where the regularization or
65
allotment.
files were used to issue.
Yes,
These files were used to issue regularization extension order by the deputy commissioner.
yes.
And page 62 is
It's
mutation orders.
mutation orders,
For the, okay.
yes.
Okay.
Yes. I may be allowed to continue page 63.
Yes.
In normal procedure followed for mutation of land application submitted by any individual for mutation is first signed by AACR/RO and is endorsed to the record branch. The record branch then prepares detailment order which is signed by AAC revenue/revenue officer. The record branch then send the application to the LRSO requesting to depute the concerned surveyor to survey the land. The surveyor then goes to survey and survey the land in question and prepare a trace map and survey report report to the of the area, after which the LRSO signs in the trace map and send back the documents to the record branch. 1 month notice is issued duly signed by the RO/AAC Brigade R, which is published in local newspaper for any objection. After the expiry of 1 month, if there is no objection, the applicant will submit the notice to the record branch. Case record will be prepared accordingly for mutation, which will be signed by AAC followed by RO, ADC, and DC. The statement given by the investigating officer by the surveyor reveals the reason for non-availability of the case record in the DC office Dimapur. The surveyor in the record branch admitted that normal procedure was not followed till 2016. Procedure was followed only after posting of Sri Kisonyu Yomi as DC Dimapur during 2016. It is further stated by the surveyor that prior to 2016, not only the case of mutation without following procedure, there is possibility of allotment of land in PWD colony Dimapur directly from the ROEAC Brigade R level in connivance with the record branch or from the record branch itself by passing the ADC in DC. It is therefore established that any mutation effected without the approval of the then ADC DC is outside the procedure and therefore illegal. The evidence collected in the form of documentary and statement of the officers and staff connected with the case, the investigating team established that, number 1, the claim of the occupant of the PWD quarter in PWD colony Dimapur that the Pata issued to them was against the standing government quarter, Iakubai. This claim is not tenable as there is standing government order against allotting land along with government quarter standing thereon. Further, the administrative officer who has issued the Pata has denied issuing any Pata against standing government quarter except open space. Surveyor who have surveyed some plot of land has stated that they have surveyed only empty land and not the land where government quarter was standing. Number two, some occupants of the PWT quarter at PWT colony Timapur are in possession of mutated patta, which land covered by the patta belong to another colony as per the record in Chita, Chamapandi, tag number, Mausan number, Brigade colony, and statement of the surveyors of the record branch TC office. Number three, some occupants of the PWT quarter at PWT colony Timapur are in possession of patta which is already cancelled by the TC office Timapur. Number four, some occupants of the PWT quarter at PWT colony Timapur are in possession of settlement order issued in 2004 and 2008 respectively. As per the statement of the surveyors, settlement orders are issued only for land situated in village area and not in government's land. Number five, some occupants are in possession of regularization order processed from village land files PWT at Dimapur comes under cadastral land and not under village land. Number six, some occupants of the PWT quarter at PWT colony Dimapur are in possession of patta claiming the land against the quarter. However, the class of land mentioned in the land pattas are either residential B, residential C, residential D, parents, paniketi, etc. And therefore the patta in their possession do not cover the land where the government quarter is standing. As regard the pattas issued against the parent land and paniketi in PWT colony Dimapur, where there is standing PWT quarter, suffice to say that the pattas are fake as there is no large parent land in Panikiti in PWT colony Dimapur. Number seven, barring few numbers, majority of the PWT occupants of the PWT quarter in PWT colony Dimapur are government officer and staffs, and the patta T are in possession are issued to their next in kin. Based on the information facts that has been established by the investigating them, the following pattas are to be cancelled by the Deputy Commissioner after following procedure. Here is also one of the lapses that I've been giving. It's a order. So
What is number three?
number three, my lord, this is in respect of the petitioner, in respect of the petitioner.
Nothing is, you have erased everything.
In what? So,
You show him this? Yes,
yes,
show him this. Nothing is feasible.
it is with a reference to other order which has been the similar order which has been annexed with the other petition. Number three, it pertains to the petitioner, my lord. The occupant is in possession of a cancelled.
No, I am asking about the petition which I've just handed over.
Yes. It is not so legible.
Not so legible, it is not legible at all.
Yes. So I'll produce a legible copy so that the court can have an access to that.
You let him write handwriting
All right.
and sign it. At the first instance, you should have checked.
I was not aware that the copy it was. So I may be allowed to write out
Don't
in
make
this.
that excuse. You are the author of the petition.
My lord, for any reference, we have a clear legible copy. Actual picture.
This is a different writ petition. Don't confuse. The petitioner 113 is a Bendang, this Bendang Mern.
Yes,
Then how this T Achila?
the quarter was allowed in the name of T. Achila, my lord.
Then why this how this T Bendang Mern is in the picture?
Yes, here the fact is that, my lord, I have purchased this particular land from a different person. So after applying all mutation process, I was given a pata, the land pata appearing 1309 by the Deputy Commissioner Office. That was my land pata, my lord. And the other portion is that as per the finding by the Lokayukta or the investigating agency, I was holding a cancelled land pata, and it is very much fact that at no point of time, even at this juncture also, my land pata has never been cancelled by any authority. And to that extent, the court, this honorable court has given a direction to the state to verify and ascertain whether my land pata has been cancelled or not. And it has come to the light that it is not cancelled. There is a report, I believe, that the counsel for the state.
In this case,
Yes,
there's a report.
yes, I believe, because the government was given a direction by this honorable court.
Okay. So this what is the name of Bendang Mern in this order?
My lord, that's why in this order, my name is reflected. It is the very page that we are making a reference, 1309. The land pata is in my name, Bendang Mern.
No, but here actually like water and the occupant is T Achila.
Yes. So the land has been regularized in the name. I may be allowed to refer to the main portion of the petition, my lord. The facts are highlighted in my petition in paragraph.
Okay, okay, we'll come to that after. Let us first finish with the impugn order. Yes.
So for page 65, 67, 66, 67, 68, 69, 60 till 68, it's a chart which has been prepared. So if
You are only concerned with the serial number 3.
yes, my lord.
So this Bendang Mern is the patadar
Yes, my lord.
from whom the petitioner has purchased the land.
He has
Correct.
purchased, yes, he has purchased the land from Sri Tamchin Yanga.
Are bhai, where all these names are coming again?
That's why, Your Honor, to highlight this facts, in my synopsis, in my petition also, I've make a clear reference. I've annexed documents to that extent also to substantiate my case.
If this order is not against you,
My lord, I'm saying, my name is Pendangman, the petitioner who is here.
here this is T Achila, against whom the impugn order is issued.
No, no, my lord. Achila is the wife.
of,
Pendang Meran.
okay, say that, say that.
Yes, yes. No.
Okay, actually. So here, actually, you mean to say that the building has been allotted to Achila?
Yes.
Land has been regularized in the name of Bendammer. Is it?
No, in the name of the earlier owner, which I've already reflected in my petition. It was Thamjin. So I purchased the land from Thamjin.
Then how Bendammer?
Pendang Meran. So after purchase of that land and the mutation process was completed, I was issued with the pata number 1309.
Ah,
So my name has been reflected in the order also, and my land pata has been reflected. That is what I'm trying to make out, my lord. If your lordship would kindly make a reference.
So
Synopsis.
these are facts not to be adjudicated before this court. Oh, Bendang Meran, son of So Bendang, Achila is the wife of Bendang Meran.
Yes, my lord.
Okay. And you had purchased the land from earlier Patadar.
Yes. I've clearly stated in my petition and the earlier documents.
We are coming to part two, no? This part two.
Yes, part two.
Okay, go. Proceed. Let us see what I understand.
Yes. My lord, so the other portion of the pitch is not so relevant.
And this does not concern you.
Yeah. So
Other serial.
pitch 69.
What about page 66? Doubtful and requires thorough. You are not concerned with this also. You are not concerned with this also.
Yes, I'm not, my
You're
name
not
is not
concerned.
reflected here.
Ah,
So I'm not.
So now we come to page
69. Illegal regularization settlement extension order, that
page
is.
69.
Yes.
Regularization.
Yes.
Whether it starts with regularization.
Here, my lord, if the court allows me a minute, I'd like to take a reference to this.
I am asking you whether actually like in page 13, this it starts with regularization in the second portion.
Illegal regularization, my lord. Yes.
That is not there here. You have stitched. You have made the case only for you, not for the court. Given, how do the court read all this?
My lord, it is illegal regularization, so.
How do I read?
Yes, yes.
That is not there.
This is
I think we give you time Thursday. You make all those corrections, you make all those things and come.
Okay.
Mr. TB. I think I am unable to read all his petitions because he has stitched this petition for himself, not
No.
for the court.
Lordship may keep it part third, and Thursday we can
Hmm.
take up.
Mr. Bendang Wabang. Jamir.
No, only Pendang Wabang. That is my.
Mr. Bendang Wabang. The learned counsel for the petitioner. Shall compile the writ petition so as to make it legible for the court. See everything. I am just giving a general order. Page wise, see everything. You are stitching all the pages. and making your documents not legible for the court.
I'll rectify that.
You rectify, you compile it once again.
Yes, yeah.
Listed as spotted on Thursday, that is when?
17.
On 17/10/2020. Kindly see you actually recompile all this.
For hearing item number 13.
May I please, Your Lordship?
Yes.
Lordship, if this matter can come up after 2 weeks, Lordship.
Why?
Lordship, I have to go to the brief, Lordship. Since
This is
this,
2020, you take 4 years to go to the brief.
Lordship, earlier this matter was handled by my colleague, Ms. Livika, Lordship.
But on 23/9/2024, we have recorded your name.
Lordship. So if Lordship may please grant another 2 weeks time, Lordship, so that I have taken the consent, Lordship.
Yes, Mr. Moore.
Lordship, in addition to that, as per order dated 16/4, the government is here to file an affidavit, Lordship. This honorable court has given a direction
16/4.
16/4/2024. The matter was heard on that particular day, Lordship. And during the course of hearing, Lordship, this,
16/4, just wait.
Yes, Lordship.
16/4,
yes, Lordship.
16/4/2024.
Yes,
Shall on the next date come with proper instruction as to how the petitioner's salary, who is an employer, was fixed as per ROP 2007 till March. Instruction shall be in the form. Take note of this order.
Lordship.
Take note of this order.
No.
Order dated 16/4/2024.
Lordship.
On the prayer of Mr. V. Jamomi, the Lieutenant Government Advocate. Release the keys. After 2 weeks. Stop. The Lieutenant Government Advocate. Shall also comply with the order dated 16/4/2024. And file the affidavit
Lordship.
as directed.
obliged, Lordship.
For hearing item number 14.
May I please, Your Lordship?
Yes.
Lordship, I effect mention on behalf of Thiba Home Lordship. Kindly list this matter on 17 Lordship.
What is 17? Thursday?
Thursday Lordship.
Thursday, it may be difficult. We list it next Tuesday. What is the matter?
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 14 on behalf of my senior counsel, Sir Senti Younger, that
What
Your
is the
Lordship.
matter? What is the matter, Mr.? What is the matter?
Sir, the matter is between Sir Sri E. Victor Jami versus the state of Nagaland. And
I know that. What is the matter? What is the subject matter?
sir, I'm not aware of it. Sorry, sir.
I have told the junior advocates not to come with this kind of instruction. I don't know.
Sorry, Your
That will
Lordship.
not help you in your profession. That will not help you in your profession.
Sorry, Your Lordship.
That will not help you in your profession. At least you, when your senior instructs you to make a mention, kindly ask your senior, what is the matter? At
Yes,
least
Your
the subject matter, the basic subject matter. What is the subject matter? Yes. What is the subject matter?
Lordship, I'm not aware, Lordship.
Equally. Who is the senior?
Senti Younger.
Mr. So-and-so makes a mention on behalf of Mr. So-and-so, Lieutenant Counsel, makes a mention on behalf of Mr. Cynthia, the Lieutenant Counsel for the petitioner and seeks adjournment of the case for 2 weeks. Prayer is allowed. Let's record.
Obliged, Lordship.
Much obliged.
For hearing item number 15.
Yes, Mr. Moore. What's the matter?
Lordship, the matter pertains to invalid pension, Lordship. The petitioner served for 7 years and he has resigned from service, Lordship.
Where is the accountant general? Where's Mr. Joshua?
Lordship, during the course of hearing, Lordship, one name, the Commandant 11 IR, Battalion Chumuktima has been implemented as a party, Lordship.
Why, Mr. Moore, why commandant has been?
Lordship, since the resignation was submitted to the commandant, this honorable court has given a direction to implead the commandant, which I have implemented and filed this amended petition. Notice has gone to the newly implemented respondent also, Lordship.
You have filed amended petition?
Yes, Lordship. Yes, Lordship.
Impleading the commandant?
Yes, Lordship, as respondent, Lordship.
Number 6.
Respondent number 6.
Okay, you can take notice.
Lordship, on the last occasion, they have implemented and they have served it through registry.
No, in fact, actually.
If necessary, I can serve extra copies and get instruction, Lordship.
Actually, like, no need notice, you are here.
Lordship.
You are here, you are entrusted with this responsibility.
Lordship, then I will accept notice on behalf of respondent.
Yes, you serve copies.
Lordship.
So Joshua, I thought, pension, I thought you will require you, but,
Well,
it seems, I think notice is not completed.
Lordship.
Mr. Mojamir, the learned counsel for the petitioner shall serve a copy of the writ petition shall serve the requisite copies
Lordship.
of the writ petition to Mr. V. Jamomi, the learned government advocate, who also represents the newly implemented respondent number 6. The requisite copies shall be served
During the course of the day, Lordship.
in the course of the day. Listed after
2 weeks.
2 weeks. Okay,
Likes, Lordship.
yes.
For hearing item number 16.
This Lordship.
Lordship,
I have instructions to file objections to the affidavit in reply filed by petitioner, Lordship.
oh,
So Lordship, can grant me 2 weeks time, Lordship?
petitioner as well affidavit in reply.
Yes, Lordship.
You filed,
Yes.
is not objected to. As a. MS. S. Chong. A learned government advocate submits that she has instructions to file objection to the affidavit in reply filed by the petitioner. And therefore 6 for 2 weeks time.
2 weeks, Lordship.
Where is law listed according?
Much obliged, Lordship.
For hearing item numbers 17 and 18.
Lordship,
Yes.
my senior is on his way. Let it be listed after the listed item.
What is this case? The case which I did not understand in spite of 2 hearings?
It's about illegal discharge on incurring foreign injuries, Lordship.
Okay, we'll just see with it. Because one case, I think similar, I have heard Mr. MT for two days. I have not understood his case. Let us see. What about CGC? We'll list it on Thursday. Let us see. List it again on Thursday. Okay.
Should like, okay,
Yes.
Lordship.
For hearing item numbers 19 and 20.
Yes, Mr. PB.
Yes, Union. Your Lordship, here the petitioner is challenging the advertisement issued by the Union Public Service Commission for appointment to the post of assistant horticulture specialist, that is item number 19. Item 20 is horticulture specialist. On the ground that one of the main ground is that since they have been appointed after going through regular selection process by way of advertisement, your lordship, and they're still holding the post, they should be regularized. That is the case, your lordship. And now, when the petition was moved, on the day the petition was moved, an interim order has been passed, staying that advertisement, your lordship, so far as the post of the petitioners are concerned. And presently, I'm still continuing. So far as the post in respect of the petitioners in 19 and 20 are concerned, your lordship, the process was not initiated. Then I'm still continuing.
Yes, Mr. Yangarwati. Why don't you consider they are overaged? Correct.
Yes,
Their appointment was on contractual basis. And the two posts has been negotiated.
Are you also giving opportunity to them to appear in the advertisement?
Yes, they can apply, yes.
Have you given them age relaxation?
No, your lordship, that is as per the age limit. I am now in 18 years I'm serving, your lordship. Now,
What is your age now?
now 55 years, maybe
That's
even
what-
going by the age, your lordship, I have, in fact, I have
Almost retired.
sacrificed my prime youth in serving the department. I have
You're 55.
55. So I have only 5 years left, your lordship.
When was the advertisement issued?
Advertisement, your lordship, come to that. May 2023.
May 2022.
It's more than a year now.
You actually took up the job on contract basis pursuant to an advertisement.
Yeah, on contract basis, my case, so far as my case is concerned, your lordship.
No, your contract was pursuant to an advertisement.
Pursuant to an advertisement, both in local and national paper, regular selection process was done, interview, and I've been appointed by a competent authority, your lordship. Now, initially, my appointment was as consultant technical, your lordship. But then, and the post is in Central Institute of Horticulture at Metsufima, your lordship. And there is no post of consultant technical in CIH, Metsufima, your lordship. Therefore, I am always shown as assistant horticulture specialist, AHS, because that is a sanctioned post, vacant post. So as technical consultant, I was appointed on contract basis, but since there is no post of consultant technical, I'm shown as assistant horticulture specialist.
In the appointment order.
No, in the appointment order as consultant technical, but in the sanctions, the sanction strength, your lordship. Against assistant horticulture specialist, my name is shown. So I am treated
Against assistant?
horticulture specialist. So I am treated as assistant horticulture specialist.
Though you were appointed in the other technical.
As consultant technical, because that post of consultant technical is not there. The sanction post, your
That's
lordship.
why. The advertisement was for
For consultant technical,
consultant technical.
within bracket technical, say technical consultant, whatever, as consultant.
And you were appointed as?
As consultant technical,
Yes.
but there is no post of consultant technical in CIS Metsufima. So I am shown as occupying the post of assistant horticulture specialist, which is a sanctioned post. So what I'm trying to impress upon your lordship is that there was a vacant sanctioned post of assistant horticulture specialist, but without advertising that post, AHS, assistant horticulture specialist. Advertisement was made for consultant technical, which post is non-existent. And I am appointed on contract basis on fixed pay. Had I been appointed as AHS, which is a sanctioned post, vacant post, then my appointment ought to have been regular and on scale pay, Your Worship. But I am still being paid fixed pay. And there's also a letter from
Because you were appointed against a non-existing post.
a non-existent post. Advertisement was made, though there was AHS post was there, and I am shown as appointed as technical consultant technical, but I'm sure in the strength, cadre strength, I'm shown as occupying the post of AHS. So though I am appointed as per my appointment order, I am appointed as consultant technical. I am treated as assistant horticulture specialist. And in fact, there's also
You were appointed as the TV
consultant within bracket technical.
consultant.
That is technical consultant. But I am treated as assistant horticulture specialist, AHS.
Horticulture.
The facts are very small, Your Worship. And I'll be just placing 2-3 judgment, Your Lordship, on where selection appointment was made after going through selection process.
No, that okay. That you were actually appointed on contract basis on the basis of a selection process.
Yes.
The only issue what is worrying this court is that you were not appointed against this assistant. You were not appointed against this assistant horticulture specialist. You were appointed only against consultant technical.
The ground taken in the affidavit in opposition by the respondent is that RR recruitment rules does not provide for absorption of contract employees. That is one. That is why my case could not be considered. That is one. I'll satisfy Your Lordship that the rule clearly provides, Your Lordship. Second ground taken is that the legal ground taken is that because of Uma Devi, my case for regularization cannot be taken. But Uma Devi will apply, Your Lordship, only in those cases where appointment was made without going through any selection
You mean
process.
to say that you fall within that one time?
No, not one time. Uma Devi does not apply in my case because my selection appointment was through a regular selection process, only except for the fact that it was on contract. But Uma Devi will come only if appointment is made without going through regular selection process as per constitutional mandate, Your Lordship. And even in those cases where appointment is made without going through a regular selection process, paragraph 53 will that one time.
But Mr. TV,
Lordship.
whether this court has the power to direct regularization?
Lordship, I will satisfy Your Lordship with case laws. I will not say that, Your Lordship. I will satisfy Your Lordship with case laws, that's all.
Yes, Mr. Yangawati. Why don't you at least consider? You have taken the service of the petitioner for so many years. He is on the verge of retirement at least. I think the government should also treat their employees with a human face.
Mr. Lordship, if my Lordship may come to page 14,
read what
page
it says.
14 of my, it says, this is the Government of India, Ministry of Finance, Department of Expenditure, so it's the proposal of Department of Agriculture, Corporation and Farmers Welfare for creation of 16 posts of Central Institute of Horticulture, Mechapima Campus, Dimapur, Nagaland, has been examined in this department and agreed to the revival of 16 posts at Central Institute of Horticulture, subject to the condition that these posts are filled up on regular basis as per prescribed recruitment rules only. So all posts should be filled up only through the prescribed recruitment rules. And I have said in my,
When the petitioner was first appointed on contract basis,
yes,
was any rule followed?
As per the terms and conditions of the appointment, Lordship, the appointment is barely for temporary period. Then the contract appointment shall not confer any right for regularization or absorption in the post. That is one of the conditions.
Mr. TB, you are on a weak wicket. Let you satisfy this court with
Lordship,
your judgment.
Lordship. No, just the facts are very brief, Your Lordship. Might just take Your Lordship to the how my appointment was done, page 17. Just facts will take only 10 minutes, Your Lordship.
Page 17.
Page 17. Just 10 minutes, facts will.
Your petition, correct?
Lordship. Nature one, Lordship.
Yes, read petition. Is it continuation or this is that appointment order itself?
No, there's the note 17, Your Lordship has got it.
Yes.
This is regarding engagement of 4 number of consultant technical for CIH Nagaland on contract basis for a period of 1 year with a consolidated payment of rupees 20,000 per month. Based on the approval of competent authority, applications were invited for engagement of 3, I think this typing mistake, it should be 4 consultant technical through advertisement in 3 leading newspaper in Northeast region and 2 national papers. We have received 11 applications, of which 7 eligible candidates were interviewed by a selection committee headed by a horticulture commissioner on such and such at Kohima, Nagaland. The other member of selection committees are as below. Your Lordship may come to the.
So where is the advertisement?
The advertisement I have not annexed, but it is not disputed, Your Lordship. It is their own record. This is by Deputy Commissioner Horticulture. This is their record, Your Lordship. It is not disputed, Your Lordship. Now, third paragraph from bottom. Based on the recommendation of selection committee and on careful observation, it is proposed to engage the following 4 number of candidates as consultant on contract basis. My name appears as serial number 3, Arvind Singh. Is a petitioner, Your Lordship. In this regard, we basic the approval of secretary such and such for engagement of 4 number of candidates as consultant technical CH Nagaland on contract basis for a period of 1 year on payment of consolidated amount of such and such month to undertake various activities of the institute submitted for kind perusal. This is signed by DC Horticulture and OSD CIH. Next page, Your Lordship.
Yes,
This is the appointment order.
advertisement. Okay. Yes.
Page 18, Your Lordship, is the appointment order.
Yes.
I am to convey the approval of the competent authority in this department for engagement of Sri Arvind Singh as consultant technical on contract basis in CIS. This is the petitioner. Period of engagement, first number 1, that is 1 year, 2, remuneration to 20,000. Now, next page is the extension order.
Page 19.
Page 19. So this is the last extension order. The contract service was extended from time to time, and the last extension order.
6 months. This is for 6 months.
Yes.
And this is the last
This is the
order?
last extension order. It was, the service was extended from time to time, and this is the last extension order.
This is last extension order is 22.
13/10/2022.
Okay. This is the last extension order done.
Now, Your Lordship. may I take your lordship to page 21? This is the incumbency list. Lordship has got it.
This is a proposal.
The subject is there, but lordship may kindly come, number one, details of sanction incumbency list, sanction post incumbency list at CIH Mitsipima.
Proposed on engagement of this interest. In response to the details of sanction incumbency list, sanction incumbency list.
This is the incumbency list in CIH Mitsipima. Now, one post.
Yes, yes.
Lordship, director, one post, horticulture specialist, two posts. This will be also relevant because in the second writ petition, your lordship. Mr. Anjani Kumar Singh, he is the petitioner in the second item, your lordship. Now coming, lordship may come to serial 5. Assistant horticulture specialist, your lordship has got it. Now, sanction post 3 and my name is shown against that post.
What is this page 20?
Page 20, your lordship, this is request for extension.
No, Mr. TB, after the last extension order,
Yes, lordship.
where is your continuity in service?
Then thereafter, during the pendency of this, my service has been extended, your lordship.
After the last extension?
Yes, during the pendency, your lordship. I am still pendency of this writ petition. I am still continuing, your lordship. So I have not taken your lordship to this. Now, serial number 5, your lordship, that is the sanction post of AHS, Assistant Horticulture Specialist, the 3 posts, and I am occupying one of them, Mr. Arvind Singh, your lordship. Because as I've said, your lordship, there is no post of consultant technical in CIH Mitsipima, your lordship. Now, total sanction post, incumbency list, your total sanction post, lordship, is 17. This also is relevant, your lordship. Because coming to the next letter. Next, may I take your lordship to?
What is this? The proposed outsourced staff are to be engaged over and above the 17 notes, as well as 61 sanction outsourced labels for.
We are not concerned with this. Outsourced staff means the subject, your lordship. This is proposal for extra additional 2 data entry operator, 2 multitasking staff. This is the outsource extra. Lordship may kindly see the subject proposal for engagement of 2, because these 2 posts, these are extra in addition to the sanction posts.
Which?
The proposed outsourced staff are to be engaged over and above the 17 number of sanction posts. Lordship has got it. So I've taken your lordship to page 21 just to show the incumbency list in CIH Mitsipima.
So
and
this was the first time you were shown as this assistant horticulture.
Yes, but this is record, their own record, your lordship. Now, may I take your lordship to page 23, the type copy, page 24. Page 24 is a type copy.
Page 20. What is page 24? The enhancement of.
This is a continuation of page 21.
Which one?
This is proposal.
This is page 23.
page 23, type copy, page 24.
This is regarding enhancement.
Enhancement of remuneration in respect of A.K. Singh and Arvind Singh, technical consultant, CIS, Nagaland. Your
You
Worship.
also again technical consultant.
Yes, initially appointed as technical consultant, subsequently again by way of advertisement in the selection interview he appeared, and then he was appointed as horticulture specialist in the second petition. So the first petition, this petition relates to the post of assistant horticulture specialist.
Now, for the post of assistant horticulture specialist, was there an advertisement?
Which is under challenge. Now, recently they have advertised.
That impugn.
Yes.
But before that, to appoint you on contract,
Yes.
there was no advertisement.
Advertisement not
It
for.
was only for the technical.
Yes, consultant, technical. In both the writ petition, Your Worship. May I read out, Your Worship? The subject is for enhancement of remuneration in respect of Sri A.K. Singh and Sri Arvind Singh, technical consultant, CIS, Nagaland. Now, I will read out the relevant para. Para 2. Subject is for enhancement of remuneration, but then in para 2, this is by the Ministry of Agriculture, Your Worship. In view of the above position, it is clarified to CIS Nagaland that these two persons would be entitled to the enhanced rate of remuneration for the post of technical consultant, that is 25,000 per month, as indicated in the Ministry's order dated 14/11/2011, and would continue to be designated as technical consultant till their engagement in CIS or their adjustment against the post of horticulture specialist, Your Worship. This would also be subject to the condition that CIS Nagaland would not engage at any time personnel in excess of the sanctioned strength of 17%. I still come within that 17%, Your Worship, and would keep other two posts vacant till these two persons continue to work as technical consultants, Your Worship. Or
What does it convey? And would keep the other two posts vacant. What does it convey?
would not engage any personnel and would keep two other posts vacant.
What does it convey?
There is two other posts out of that, because here
No, two other posts means
now
17.
The previous sentence, Your Worship, or the adjustment against the post of horticulture specialist. So they can be till the adjustment is done, they will continue as horticulture specialist.
But for adjustment, there has to be some process.
But no, that process can be followed, but no process was followed. Straight away, my post was advertised to adjust against the post of horticulture specialist, Your Worship. As Your Worship has rightly said, some procedure needs to be followed. That is fine. No procedure was followed. I was not this is by the ministry, Your Worship.
This is by the ministry, but
Yes.
the letter of the ministry cannot override the stipulation made in the advertisement. See, that is what is disturbing the mind of this court.
I'll come to that, Your Worship. I'll come to that. Now, without adjusting my post, without adjusting the petitioner against the post of horticulture specialist, Your Worship, my post was advertised, and it is not in dispute.
It is not your post. Actually, your post is technical.
That is what I wanted the respondents to take the ground in the affidavit. My post was not advertised, but that is not the ground taken. Your Worship has rightly said. What I'm saying is that I have been shown as occupying the post of assistant horticulture specialist, and without adjusting me, my post has been advertised.
TV,
Respondent
TV.
ought to have said,
Mr. TV,
Lordship.
this court is saying that you were not appointed against horticulture. What is that post? Against that horticulture?
Yeah, assistant horticulture
You
specialist.
were not appointed. That is what is concerning the code. You were appointed against a technical post, maybe in some communication. Maybe this post of a horticulture specialist may have been mentioned, but that is not the stipulation in the advertisement.
Your Lordship, in my pleading, I have taken a specific plea that the post which is advertised, one of the posts, is presently held by the petitioner. Respondent ought to have, I expect the respondent, Your Lordship has rightly said, to say that no, we have not advertised the post which has been held by the petitioner. That is what the respondent ought to have stated in the counter affidavit. So by not denying my statement, respondent.
No, but the other way around is that the respondent can always say that since you were appointed against technical post, they have advertised this the horticulture specialist post. The other way around is that.
Then, even from the conduct, Your Lordship, they have not proceeded with advertisement in filling up my post. Out of two, only one.
That is because of the stay granted by this court.
Lordship?
That is because of the stay granted by this court.
Yes, then they could have said, we said we have not. The post assistant horticulture specialist, that post is not held by the petitioner. But that is not their stand. So what I
See, their stand is that, as I understand, their stand is that you were appointed against technical. You were appointed against technical. And therefore you are not horticulture specialist. And therefore they have advertised the post of horticulture specialist.
that is not in the affidavit in opposition. Let them show. Whether the statement is
No,
there.
now, since you are the petitioner, you have to prove your case. You have to
No.
say that you have to actually satisfy this court.
Yes.
You have to satisfy this court that this technical post
Hmm.
is the post of horticulture specialist.
Yes.
That you have to satisfy.
That is what I've stated in my petition. That they have not denied it. That is the thing. If the stand of the respondent is that no, these posts are different, then none of my right. In fact, then I have no locus even the question the advertisement. I have no locus. Respondent could have questioned my locus. When my post is not advertised, who am I to approach this court?
The court is concerned with that issue. When your post is not advertised.
So Lordship may just hear me and then Lordship can pass any order.
No, please assist this court. Please assist this court because actually there is some issues which is actually of concern for this court. Because of the fact that you were appointed against a technical post. And you want to be confirmed in the post of horticulture specialist.
Horticulture till I am adjusted, or I may be allowed to continue till I am adjusted.
No,
You
but
can suppose.
as you have submitted, you are now holding a contract post.
Lordship.
So whether this court will have the power to direct regularization of your service so as to enable you to enjoy all the scale pay, the benefits of regularization.
I'll satisfy your lordship, try to satisfy your lordship
So
on
far
that.
as this court is concerned, this court will always hold that the court does not have the power to direct regularization.
That I leave it to your lordship. But so far as the second case is concerned, your lordship, that he was initially appointed as consultant technical, your lordship, and occupying the post of is shown as assistant horticulture specialist. I have taken your lordship to the strength. And thereafter, the post of horticulture specialist was advertised. He appeared in the interview. And he was selected against the sanction post on contract basis.
Second one.
Second one,
Second one.
second one.
Why not the first?
This both the petitioner in first and second, they appeared for the thing for the post of horticulture specialist, but there was only one post was there. So the petitioner here was kept in the waiting list.
So at least in the second case, I think.
He is now holding the post of
Yes,
horticulture.
second case, I think it has more weight than the first case.
I agree, because through regular selection process, he was appointed as horticulture specialist, but appointed on contract.
Ah.
So my case is that since he has been appointed after going through regular selection process, he ought to have been appointed on regular basis, not on contract.
So do you have a citation on that?
Yes. So Lordship has rightly said, second case, that way it's better. But then
First case. First case.
in the first case, Your Lordship, though, as I've said, I am holding the post. This is the statement made by the petitioner in the writ petition. I am since there is no post of consultant technical in CIH Metsifima, I am holding the post of AHS. And the post which has been held by the petitioner is been advertised without adjusting my post as per the letter, ministry letter, Your Lordship. It because a legitimate expectation is there, Lordship.
No,
But Lordship, I'll satisfy on that legitimate expectation with case laws, Your Lordship.
The basis of your appointment does not give rise to a legitimate expectation. The basis of your appointment.
I'll leave that to Your Lordship. I leave that to Your Lordship.
Okay.
Now, Your Lordship. Now, may I take Your Lordship to the pleadings, Your Lordship?
No, you have finished with your annexures.
Annexures and then the advertisement, last advertisement.
No. What is this 26? Request for consideration absorption.
For absorption, this is a request, Your Lordship. Petitioner is also there.
Arvind Singh.
Arvind Singh, petition was just a representation was submitted requesting. And coming to
And what is the
advertisement, 27.
No. Oh. There is no answer to this.
No,
26.
no. Page 27 is the impugn advertisement. So the facts is only this, Your Lordship. My post is page 28, item 3. Page 28, Your Lordship. 2 vacancies for the post of a assistant horticulture specialist in CIS, Nagaland. Age, Your Lordship, 35 years. So as I've already submitted, Your Lordship, I have challenged this advertisement, Your Lordship.
You have all the essential qualification.
Your Lordship, there is no dispute. And Your Lordship may kindly see the order dated 29/3/2023.
Yes.
Order dated, passed by this court, order dated, passed by this court, Your Lordship.
Order dated.
29/3/2023. I'll be coming to the judgment later on by course of my submission, Your Worship. The last paragraph. The last paragraph.
Just
Page 4, last paragraph, Your Worship.
of the order dated 29/3.
29(3).
Page
Page 4,
4.
last paragraph.
Council.
No, having regards to the submission,
Yes. Okay.
Your Worship has got it. Having regard to the submission made by the learned counsel for the petitioner, in the interim, it is provided that the respondent authorities concerned shall not proceed with filling up of one post of assistant horticulture specialist that was advertised through the impugned advertisement number 5 of 2023 without leave of this court. It is further provided that herein that the petitioner still continuing as consultant technical as on date, despite the contract period having been extended up to this status quo as on date should be maintained, Your Worship. Now, Your Worship, no petition has been filed, Your Worship, seeking liberty from this court to proceed with that advertisement, Your Worship. So I'm still continuing. Now, may I take Your Worship to my pleadings, just 5 paragraphs, short paragraph.
Yes, sweet.
From para 12. Just 5 paragraphs, Your Worship. Page 9.
Page
9.
of your petition.
Pleadings, yeah. My read petition. Page 9, para 12. May I read out? That as the petition has been rendering continuous service for more than 16 years, now 17 years, Your Worship, more than, and also considering the fact that even the Department of Agriculture and Corporation, Ministry of Department, Government of India has conveyed to the Director C.S. Matsubima that he will be adjusted against the post of horticulture specialist, the petitioner has legitimate expectation that he will be adjusted, absorbed in the service of C.S. Matsubima on regular basis. However, to the petitioner's utter shock and dismay, the UPSC published advertisement number such and such, inviting application for direct recruitment amongst other to fill up the vacancy number such and such, which is currently being held by the petitioner, Your Worship. This is not being disputed. It may be mentioned here that the petitioner's post is advertised under item number 3 of the said advertisement. As per the advertisement such and such for the said post, the age limit prescribed for is 35 years. Para 13, that as stated, the petitioner was appointed person to advertisement, which was duly published both in local and national papers and by a duly constituted selection committee. In other words, the petitioner was appointed after following a due process of recruitment and as per the constitutional scheme, except for the fact that the appointment was on contractual basis. 14, that as the petitioner was appointed after following due selection process, the petitioner was under legitimate expectation that his service will be adjusted, absorbed, regularized, and more so when even the Department of Agriculture and Corporation, Ministry of Agriculture, Government of India, has also conveyed to the director CIS that the engagement of petitioner in CIS will be adjusted against the post of horticulture specialist. Therefore, the action of the respondent in advertising the post of AHS held by the petitioner before his adjustment against the post of horticulture specialist is highly unjustified, arbitrary, and illegal. As such, the UPSC respondent 5 ought to be directed not to conduct the recruitment process for the said one post of assistant horticulture specialist for the first till such time the post held by the petitioner is adjusted or absorbed against the post of horticulture specialist. 15, that the petitioner is now 54 years, now more than 55 years, Your Lordship, of age. As per the advertisement, the age limit prescribed for the post of AHS is 35 years. Being so, the petitioner is already overaged to apply for the said post of assistant horticulture specialist. So even going by the age, Your Lordship, petitioner has hardly 5 years of service now. 16, that the petitioner has been rendering continuous service for more than now 17 years, and in the meantime has already become overage, and there is no other employment opportunities available for the petitioner. Therefore, in the event the post of AHS held by the petitioner is filled up pursuant to advertisement such and such, the petitioner will be left with no employment opportunities and thereby threatening even his right to livelihood, Your Lordship. Last para, that the petitioner submits that the petitioner has been appointed against sanctioned post after undergoing selection process as per constitutional scheme. Why I'm stating sanctioned post is because he is shown as occupying the post of AHS. As the petitioner has been serving for more than it should be now 17 years, the respondent ought to have considered his case for adjustment, absorption, regularization as compared by the Department of Agriculture, Ministry of Agriculture, Government of India to the Director, C.H. Matsukuma.
Who has requisitioned the post to the UPSC?
By the ministry.
Ministry.
By the ministry.
Who has written the letter that you should be adjusted against this?
Yes. Considering the representation for the absorption, regularization, or adjusting again. Next page, Your Lordship, 12. Here's the last paragraph. Against the post of horticulture specialist as conveyed by the Department of Agriculture and Cooperation, such and such, the respondents have issued advertisement. Now, my prayer, Your Lordship, prayer is 14.
What about para 18? Same.
No, these are all submission only, Your Lordship. Just I'll take your relevant portion.
Prayer.
Prayer 14, Your Lordship.
Page 14.
Page 14. Prayer A, to quash and set aside the advertisement for filling up the post of such and such, appearing item number 3, in respect of one post of assistant horticulture specialist held by the petitioner. Everywhere I've stated that, Your Lordship, this is the post held by the petitioner, and this is not being denied. B, that the direct respondent not to advertise for filling up the post held by the petitioner till such time the petitioner is adjusted absorbed against the post of horticulture specialist in terms of letter dated such and such issued by the Department of Agriculture and Cooperation, Ministry of Agriculture, Your Lordship. These are the prayer. Now, may I first take Your Lordship to the affidavit of opposition filed by the UPSC. Affidavit of opposition filed by respondent number 5, Your Lordship. Just I'll read out 2 paragraphs.
Yes, respondent 5.
5, Your Lordship. Para 8 and 9, Your Lordship. Lordship has got it.
Respondent 5 is the UPSC.
UPSC, Your Lordship.
Yes, please.
Para 8, Your Lordship, 8 and 9. I'll just read out page 4.
Yes.
2 paragraphs.
Para 8 and 9.
8 and 9. That the answering respondent begged to state that the UPSC issued an advertisement for selection and recruitment to a specific service post only on receipt of specific proposal requisition from the concerned ministries, department, complete in all respect. In such case, the Union UPSC have floated advertisement number such and such 2 vacancies for the post of AHS in CIS, Nagaland Department of Agriculture and Farmers Ministry of such and such. 9. Did the answer respond back to state that the subject matter of adjustment, absorption, regularization of the contractual employees in an administrative matter and comes under the domain of the concerned department of the central government? In the instant case, the Ministry of Agriculture and Farmer Welfare, Government of India is the concerned department concerning the grievance of the petitioner, and the UPSC has no role to play. So the affidavit in the other case also, the stand of the respondent file are the same, Your Worship. Now, may I take Your Worship to the affidavit filed by the union?
1 to 4.
1 to 4. Lordship, in order to save the trouble of my learned friend, in reading the relevant paragraphs, I may read out the relevant paragraphs, Your Lordship. Para 3, 6, 7, 8, and 9. 6, 7, 8, and 9. 5 paragraphs. Let me start from para 3, Your Lordship. The Central Institute of CIS Horticulture Measurement was established 16 January with cabinet approval. Initially, it was proposed to engage consultant technical on monthly contract basis for a period of 1 year to take up various development activities at the institute till the appointment of regular staff. With the approval of ministry, after conducting interview by temporary committee member, 4 number of candidates were engaged as consultant technical in CIS Nagaland in 2007 on contract basis for a period of 1 year on payment of consolidated amount of rupees 20,000, which is renewed from time to time for every 6 months. In the meantime, 17 posts were sanctioned by the Department of Expenditure, Ministry of Finance, by their letter dated 23/6/2006, Your Lordship. 17 posts were already sanctioned in the year 2006. My appointment is in the year 2007, Your Lordship, after the post was sanctioned, to be filled up on deputation redeployment basis to obtain regular permanent staff for CIS Nagaland. Accordingly, recruitment rules are for 17 posts of CIS were notified, and after making several attempts, no post except the post of director could be filled up as per RR recruitment rules. Since then, from 2009, these posts were also been filled up on contractual basis for a period of every 6 months for running CIS Nagaland against the sanctioned 16 posts, because excluding the post of director. Including the post of director, it will be 17 posts. Now, these posts, may I repeat, Your Worship, since then, from 2009, these posts will be filled up on contractual, these posts mean the sanctioned posts are being filled up. And my case is that I was adjusted against that post. However, Department of Expenditure, Ministry of Finance, by their ID dated such and such, agreed to revive the 16 posts of CIS Nagaland, subject to the condition that these posts are filled up on regular basis as per prescribed RR only. Accordingly, RR of all these 16 posts were notified with inclusion of direct recruitment method to recruit the regular permanent staff of CIS Nagaland. Thus, as per the direction of DOE, UPSC and Staff Selection Commission have been approached to fill up this post on DR, direct recruit basis, as per the amended RRs and advertisement number such and such under item number 3 for 2 vacancies of post of AHS in CIS Nagaland were published by UPSC to recruit regular staff in CIS Nagaland as per rules. Para 6.
Para 6.
Para 6. Page 5, Your Worship. That with regards to the statement made in para 9, it is submitted the petitioner was engaged as technical consultant on contract basis, but offer such and such. Thus, letter number such and such that is referred by the petitioner does not reflect that the petitioner is working as assistant horticulture specialist. Admitted. My appointment is as consultant technical. But I am shown as occupying the post of AHS. Para 7. That with regards to the statement made in para 10, it is submitted the petitioner has misunderstood this ministry's order number such and such, and his claim that his service will be absorbed, regularized against the post of horticulture specialist is not justified, as the appointment of the petitioner was purely on contract basis by letter number such and such. Contractual service of the petitioner had been extended for every 6 months from time to time, as per the terms and conditions of the agreement, which has been accepted by the petitioner also. Thus, the petitioner is aware of the consequence of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation or being confirmed in the post when appointment to the post could be made only by following proper procedure for selection. As per the offer of appointment such and such, contract appointment shall not confer any right for regularization or absorption in the post. Para 8. That the petitioner has continued to work as technical consultant on contract basis since his initial appointment in 2007, and he has never worked as assistant horticulture specialist in CIS. My case is that I am always being shown as occupying that post, Your Worship. However, as per Ministry's order number such and such, the petitioner continued as consultant till his engagement in CIS Nagaland or his adjustment against the post of horticulture specialist. In this regard, it is submitted that as per para 1 of the order dated such and such, it was meant for the post of assistant horticulture specialist only and not for horticulture specialist. With regard to the observation that
As per the order dated 7/12/2011.
it should be the letter dated,
The letter on which you are relying.
I think. Yes, Lordship. Let me just clarify.
That is the letter.
It should be the letter, not order, Your Worship.
Yes.
Okay, as per para 1 of the order dated such and such, it should be letter, Your Worship. It was meant for the post of assistant horticulture specialist only and not for horticulture specialist. Now, if this is accepted, then the second case is covered by this, Your Worship. With regard to other observation that CIS Nagaland would keep 2 other posts vacant till these 2 persons continue to work as technical assistant, it is submitted that this was meant only for contractual employment as per the contractual agreement accepted by the petitioner and not for absorption regularization of the petitioner to the post of assistant horticulture specialist, as the method of appointment available in the RR recruitment rules was deputation, including short-term contract, and not available as absorption or direct recruitment. Further, in support of this contention, various decisions of Honorable Court may be relied upon, amongst them one being rendered in Secretary such and such Uma Devi. That para 47, Your Worship. I will not read on. The last paragraph. That with para 9, that with regard to the statement made in para 11, it is submitted that the RRs of the post of CIS do not provide the absorption, regularization of contractual staff. There is no provision, Your Worship. As regular staff is recruited by following a proper procedure of selection through UPSC only. Now, Your Worship, I have finally replied to this, Your Worship. I'm just refer to 3 paragraphs. Affidavit in reply. Para 7, 8, and 9. Seven, 8, and 9 to my reply. para 7, that the statement made in para 6 of the affidavit in opposition, the deponent reiterates and reaffirms the statement made in para 9 of the writ petition. It is further stated that in the letter dated 27/1/2023, an actual 5-page writ petition, and which is also relied upon by the respondent themselves, wherein the detail of sanction post incumbency list is provided. The name of the deponent is entered as serial number 5. I've taken your lordship to that, and shown as assistant horticulture specialist. Therefore, it is too late for the respondents to deny the fact that the post of technical consultant held by the deponent is equivalent to the post of assistant horticulture specialist. 8. That with regards to the statement made in para 7 and 9 of the affidavit in opposition, the deponent reiterates such and such. It is reiterated that the deponent was appointed person to advertisement, which was duly published both in local and national papers and by a duly constituted selection committee after following due process of recruitment. In other words, the deponent has been appointed after following due process of recruitment and as per the constitutional scheme. Having appointed through a regular selection process, the deponent had legitimate expectation that his service will be adjusted by way of regularization or otherwise, as conveyed to the Director C.S. Metzikuma by the Ministry of Agriculture, Government of India. The deponent states that the word adjusted cannot be construed as advertisement. Means still the post is advertised. Furthermore, the respondent 1 to 4 have not denied that 2 posts should remain vacant until the petitioner is adjusted against the post of horticulture specialist. Therefore, the action of the respondent in advertising the post before his adjustment as horticulture specialist is highly unjustified, arbitrary, and illegal. Last para, 9. That with regard to the statement made in para 8 of the affidavit in opposition, the deponent reiterates as such and such. It is further stated that the decision relied upon by the respondent as rendered in Umadevi is not applicable as the respondents have been appointed through a proper selection process as per the constitutional scheme, your worship. Now, 2 legal submission has been taken by the respondent in the affidavit of opposition. Firstly, there is no provision in the recruitment rules for absorption of contractual employees, your lordship. Now, may I take your lordship to the recruitment rules? What does the rule say? Their affidavit in opposition.
Which page?
Page 30.
Starting from page 29.
Starting from page 29, yes, that's the Gazette, page 30. Short title, this is the recruitment rules. Page 31, this is the for assistant horticulture specialist recruitment rules 2022. Lordship has got it. Now, I'll just take your lordship to the relevant column. Page 32. Lordship has got it. Now, lordship will see the column is given 7, 8, 9, 10. Your lordship has got it. 7, 8, 9, 10 column number, because it starts from the column starts from page 30. Now, 32 is continuation of the column. Lordship has got it in the middle.
Page 30.
Lordship?
Page 30.
It starts from, the column starts from page 30. Name of post, number of posts, classification. The table is there below that schedule. Now, relevant column will be column 7, which starts from page 32. Lordship has got it. And this is for the post of assistant horticulture specialist, lordship. And your lordship will get it in column 1, page 30. Name of the post, assistant horticulture specialist. In the schedule. Page 30, bottom table schedule.
So this column 7 is for the post of
This is
assistant
horticulture specialist.
Just wait.
Now, it starts from page 32, starts from column 7 up to column 10. Relevant is column 10, right side corner. On top, method of recruitment, Lordship has got it. Method of recruitment, whether by direct recruitment or by promotion or by deputation or absorption, and percentage of the vacancies to be filled up by various methods. Now, 67% by direct recruitment, 33% by promotion, failing which by deputation, including short-term contract. My appointment was on short-term
This
contract.
promotion is supposed to be from which post?
Promotion that for that maybe on a feeder post, lower grade. But the stand taken by the union, by the respondent is that RR does not provide for absorption of the contractual employees. But the RR speaks otherwise, Your Lordship. Because deputation, including short-term contract.
No, that is why.
Yes.
What is the feeder post for this assistant horticulture specialist? What is the feeder post as per the RR? What is the feeder post?
Lordship, I think
Because your technical post is not a feeder post.
I think there will be a different rule for that, Your Lordship.
Now 33% by promotion, failing which by deputation, including short-term contract. Because your service is not on deputation.
Mine is short-term contract, and I've been appointed as consultant technical, but I am always shown as occupying the post of assistant horticulture specialist. And the post of assistant horticulture specialist can be absorbed. I am only countering.
Can you clarify this? %33% by promotion, failing which by deputation, including short-term contracts.
Before that, Lordship, it's a short paragraph. My learned client has already read of para 8. May I read, Lordship?
Para 8
of my affidavit.
I've already taken your motion to
My
that.
learned client has already read of.
Yes.
It says, para 8, Lordship, that the petitioner has continued to work as technical consultant on contract basis since his initial appointment in 2007, and he has never worked as assistant horticultural specialist in CIS Nagaland.
Yeah.
So he's still a technical consultant on contract basis.
I'm making that same submission. I've been appointed as consultant technical, but I'm always shown as occupying the post of assistant as per the record, not my record.
Whether actually the petitioner's service should fall within this 33% reservation?
He is a consultant, Lordship. He is not an assistant.
No, he is not, but including, because actually for promotion to the post of this assistant,
Horticulture specialist.
Yes, assistant horticulture specialist for promotion to that. 33% by promotion,
Yes, Lordship.
telling which deputation, you can bring in deputation, including short-term contract.
Mm.
So, Mr. TB, you will not come under this because you are equating your post with assistant horticulture specialist.
I am
Yes.
not quitting. Their own record is showing. I'm not submitting
That
because
is what
as per the record.
Even if you go by your submission, this,
There is
your
no-
assistant, your technical post is equated with assistant horticulture specialist.
Hmm.
So, if you are holding that equivalent post, you cannot, be appointed, to the post of, assistant horticulture specialist by way of promotion. And, therefore, you will
No.
not come within the 33%.
That is not promotion. My promotion will be, if I'm to be adjusted by work, we should be to the post of assistant horticulture specialist, like the petitioner in the second read petition, Your Lordship. From the post of assistant horticulture specialist
No,
to
but
horticulture specialist.
your short-term service, your short-term contract service
Yes,
is equivalent to assistant horticulture specialist.
yes.
So the
So,
question of promotion will not come.
yes, so I can be absorbed there. Or,
But,
until such time I am absorbed, I should not be disturbed as per the minister's.
Reference to the rules. Your reference to the rules,
Lordship,
33% by promotion.
Lordship, I'm not, I will not come up under the category of promotion,
Yeah.
but I am to be absorbed, or I should be,
That's why this court say, as per the schedule, this court does not, court does not find, the question of absorption.
because I am holding the post of assistant horticulture specialist.
And that's why, that means, if you have to go by your submission, this rule will not apply.
No,
Because this rule says promotion,
no, promotion or absorption,
33%.
Lordship.
No absorption is there, but deputation.
So deputation, including short-term deputation, so I am on short-term contract.
But you are holding the equivalent post as assistant horticulture specialist.
Yes,
So your question of promotion from technical to assistant horticulture specialist will
No.
not arise.
no, it is not a case of promotion because,
But if you are referring to the rules, it is
yes,
promotion. If you are referring to the rules, it is promotion. That's why I'm saying, if we have to go by your submission, then this rule will have no application.
no, deputation can be absorbed. And deputation includes short-term contract. So I can be absorbed against the post of assistant horticulture specialist. That is my submission, Your Lordship.
See, rule as per the schedule, what this court is saying is that you are holding an equivalent post with assistant agriculture specialist.
Horticulture
You're
specialist,
technical.
horticulture specialist.
So if we have to go by this, this 67% by direct recruitment and 33% by promotion,
No, if
you are not asking for promotion.
For-
You are asking for regularization or absorption.
absorption, if not, I should not be disturbed till my post is adjusted
That is your case,
against
but
the
the
case.
question of promotion will not arise in your case.
No.
The question of promotion is not there. Because you are holding the equivalent post.
Equivalent post.
So where is the question of promotion? That is what the,
That is my submission, Your
Ah,
Lordship.
no,
That
that
is
is what-
my submission.
your submission has confused this court.
No, then I leave it to Your Lordship, but that is what I'm submitting, Your Lordship. So the case of the respondent is that there is no provision for regularization of contract, absorption of contract.
But this,
But the rule says otherwise,
no.
because deputation includes short-term contract.
That's why this 33% relates to promotion. When you are holding the equivalent post of assistant horticulture specialist, where is the question of promotion?
No, since I am already holding the
Yes,
post.
for example,
Yes, because deputation is not promotion. And deputation includes contract, short-term contract. So I am occupying the post of assistant horticulture specialist, say on deputation. Because deputation includes,
Your case is this, your case is that you have a legitimate expectation to be observed, to be regularized.
yes,
That is your case.
yes,
But not promotion. If you actually raise the question of promotion, then I think,
not promotion.
that is why I'm saying, that is why if you are not raising the question of promotion, then you should not rely on this rules. 33% by promotion.
But since I'm already on, since I'm already on deputation,
Understands.
I am already on deputation.
You cannot say that actually you fall within this 33% promotion. Because you are holding equivalent post.
I am on deputation holding equivalent post, so I can be
You are
absorbed.
not on deputation.
Yes.
You are
No.
on contract.
Lordship.
You are on contract as technical.
Yes.
And technical is equivalent to assistant horticulture specialist.
Lordship.
So when you are holding a contractual post which is equivalent to assistant horticulture specialist, where is the question of promotion? That is what I'm saying. This rule has no application.
My submission is this. Why I'm saying that I am on deputation, though I am not, because deputation rule says includes short-term contract. So deputation and short-term contract, they are.
Mr. TB, you have to read deputation short-term contract service.
Yes.
On line that you are holding a lower post.
No.
On line that you are holding a lower post because actually 33% is promotional. Promotional.
Deputation cannot be on promotion. Deputation, a person may come on deputation to have one post and then he can be regularized, absorbed on that post.
We can see. Deputation can be against the higher post.
Yes, or against the same post.
Against the same.
Yes, yes.
You are holding the same post. If you say deputation, then you have to be like appointed to horticulture specialist.
Lordship, may kindly see 33% by promotion, failing which, if it is not by way of promotion, Lordship. So these are these are separate.
Failing which means if promotional posts are not available. See.
Then it is for the respondent.
No. We can just by a mere perusal. 33% by promotion. That means if promotional posts are not there, then you can bring in person through deputation, short-term contract service. Correct. But bringing in deputation, short-term contract service should be in the form of promotion. You are holding a post which is equivalent to assistant horticulture specialist. That is why actually we are having this.
Lordship, may kindly take into consideration the fact that I am not questioning the promotion of some other.
No.
I am questioning that appointment, direct recruitment.
Correct. That is
the thing.
That is why this code is correct me if I'm wrong. This code is actually this code is of the view that your case is absorption, regularization,
or till such time.
Because you have a legitimate expectation, considering that the letter dated 21 so and so, and considering that you have worked about 16, 17 years.
And then through a regular selection process.
So that is your case.
Yes.
Your case is not a promotion. So let us omit this rules. Let us omit these rules. Because by bringing in these rules, I think you are making the issue more complicated.
They have brought it, Your Lordship. The respondent.
The respondents have brought in
this
to make us to actually say that actually like the advertisement to the post of this assistant so and so.
Assistant after the break, Your Lordship.
Yes, we continue after the break.
Your Lordship.
Kindly have a thorough research on that.
Yeah, I'll just make my summary. I'll leave it to Your Lordship.
No. It's we have to help each other.
Yeah.
Okay.
Dia tahu, tapi naik, panjang lagi mana? Gue ada tuh lebih saya jadi jadi. Bukan kan ini, banyak di kita semua.
Simple. Don't fix on Thursday. We have one part of the matter.
Take 2 weeks of this.
Thursday again, you'll have to wait.
Mr. Lordship.
Yes,
Lordship, I would like to mention item number 21, 22, and 23, Lordship. Hearing item on behalf of S. Mayor Lordship. If Lordship, you can leave this matter after 3 weeks, Lordship.
well, 3 weeks. 21, 22.
23.
Yes, Mr. Tushi.
Yes, yes.
Are you agreeable?
Okay, Your Lordship. No objection.
No objection.
Yes.
MS. Yes, Chan. Learned Government Advocate makes a mention on behalf of MS Ismaili, the Learned Government Advocate, the Learned Senior Government Advocate, and seeks adjournment of the case for 3 weeks. Stop. The same is not objected to by the Learned Counsel for the petitioner listed accordingly.
Much obliged, Lordship.
May I please, Lordship?
Yes,
Now, Your Lordship, the first objection taken by the respondent is that the RR does not provide for absorption of short-term contract employees. Now, my submission is that there is provision in the RR which provides for absorption of short-term contract employees because the petition includes short-term contract employees. That is first. That is my submission to that. The second objection taken is that Uma Devi does not permit for regularization, Your Lordship. On that, I'll just take Your Lordship to case law, Your Lordship.
you are coming to case laws.
Yes, Lordship. Yes, the main two objection on that objection taken by the respondents, Your Lordship. Now, the first,
This is
this is
Kumar.
Vinod Kumar versus Union of India, Your Lordship. And this order has been passed in the bottom, it is given SLP civil, Your Lordship has got it. Case number. SLP numbers 22241-242 of 2016. Now, relevant paragraph, Your Lordship. When we start from para 3. Dear Your Lordship, I'll have to refer to a few paragraphs. It's a short judgment.
Para 3.
Para 3.
So, okay, let us see.
Person to note.
Just with SLP number 2224. You're referring to which paras?
Paragraph 3 to 6, 8 and 9.
3 to 6.
8 and 9.
And 9.
9.
Yes.
Mayor. Pursuant to notification dated such and such, the applicants were initially appointed to ex-cadre post of accounts clerk after a selection process involving written tests and viva voce interviews. After the rejection of their representation for regularization to the divisional railway manager in 1999, the appellants approached the Central Administrative Tribunal by way of original applications. The tribunal, by order dated such and such, dismissed the application of the applicant, concluding that their appointment were temporary and for a specific scheme, thus not entitling them to regularization or absorption into permanent post. Thereafter, the appellants approached the High Court and the High Court upheld the order of the tribunal and dismissed their writ petition, observing that the appellants' employment under a temporary scheme could not confer upon them the rights akin to those held by permanent employees and relied upon the judgment of this court in such and such Uma Devi, which held that temporary or casual employees do not have a fundamental right to be absorbed into service. The appellants have approached this court arguing that the High Court erred in its judgment by failing to recognize the substantive nature of their duties, which align with regular employment rather than the temporary or scheme-based role they were originally appointed. Furthermore, their promotion by a regularly considered department DPC, the selection process they underwent, and the continuous nature of their service for over a quarter of a century underscored their arguments for regularization, and that the High Court has incorrectly applied the principle from the case of Uma Devi. Having heard the argument of both the sides, this court believes that the essence of employment and the rights thereof cannot merely be determined by the initial terms of appointment, when the actual course of employment has evolved significantly over time. The continuous service of the appellant in the capacities of regular employees, performing duties indistinguishable from those in permanent posts, and the selection through a process that mirrors that of regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. I take your lordship to para 6. Since I'm only on Uma Devi, that the application of the judgment in Uma Devi Supra by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued the service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and a subsequent circular followed by a selection process involving written tests and interviews, which distinguishes their case from the appointment through backdoor entry, as discussed in the case of Uma Devi. My entry is not backdoor, Your Lordship. May I take Your Lordship to para 8? In the light of para 8. In the light of reasons recorded above, this court finds merit in the appellant's argument and holds that the service condition as evolved over time warrant a reclassification from temporary to regular status. The failure to recognize the substantive nature of the roles and their continuous service akin to permanent employees runs counter to the principle of equity, fairness, and the intent behind employment regulation. Accordingly, the appeals are allowed, the judgment of the High Court is set aside, and the appellants are entitled to be considered for regularization in their respective posts. The respondents are directed to complete the process of regularization within 3 months from the date of the service of this judgment. Now, why I'm relying on this judgment, Your Lordship, is that the manner in which the petitioner has entered the service is not through backdoor. It was by way of advertisement, both in national and local paper.
Whether it's the TV, whether under Article 226, this court has the power to regularize. Maybe this is under 142.
Your Lordship,
226.
no, Your Lordship. Now, in my respectful submission, Your Lordship, whenever any order is passed under 142, Your Lordship, the Honorable Apex Court specifically mentions in exercise of power under 142, because 142 power is an exclusive inherent jurisdiction of the Honorable Apex Court. So the High Court cannot pass any order, and that is not in fact binding on the High Court also. And whenever such order is passed under Article 142, specific, in my respectful submission, Your Lordship, because when no mention is there regarding Article 4, that is in excess of power under Article 42, Your Lordship. So, in my respectful submission, this is not an order passed under 142, Your Lordship. Now, so my respectful submission, now regularization, given direction, that is different, Your Lordship. But when it comes to application of the law laid down in Uma Devi, Your Lordship, now, since my entry is not through backdoor, in my respectful submission, the Uma Devi does not apply to the in the case of the petitioner, Your Lordship. Now, those are the two grounds which was taken by the respondents in the affidavit in opposition. Now, my grounds for seeking relief, ground on which the petitioner is seeking relief. Now, first ground, Your Lordship. Now, as per the record, Your Lordship, the petitioner is appointed as consultant technical by a competent authority after conducting a regular selection process. Now, I have taken Your Lordship to the strength, cadre strength.
Have you enclosed the advertisement?
That is not disputed, Your Lordship, their
No, that's
own
not
record.
disputed, but this court would certainly like to go through that advertisement also.
No, that.
That is not disputed, but I think there's nothing wrong for this court to go through that to get more better ideas of the case.
Then Your Lordship may give me time, I'll place it.
No, it's all right, we will, but continue. But please.
Oh.
The first
There's-
advertisement.
There's
Yeah,
the impugn advertisement. No, Your Lordship. Now, I've also taken Your Lordship to the strength, cadre strength, Your Lordship, incumbency list. There is no post of consultant technical, though I was appointed as consultant technical through a regular selection process, and I've been adjusted against the post of assistant horticulture specialist, Your Lordship, which is a sanctioned post. Now, they could have, since the sanctioned post was there, vacant post, they could have appointed the petitioner or issued the advertisement for filling up the post of assistant horticulture specialist. That they have not done. But by appointing me as consultant technical, Your Lordship, and adjusting me against the post of assistant horticulture specialist, I have been deprived the benefit of the skill pay, which is entitled to assistant horticulture specialist, Your Lordship. And on fixed pay, I've been given on temporary basis, Your Lordship. And therefore, the action of the respondent is not fair and just, Your Lordship. And in similar matter, Your Lordship, may I take Your Lordship to the second case law? This is by the Honorable High Court of Manipur.
Yes, please. Yes, please.
Here, relying on
Just wait.
relying on decision passed by the Apex Court,
Just wait, just.
Lordship. So here,
This is WPC 519.
519 of 2018, Your Lordship.
Which paragraph? Which
3.1,
3.1,
3.3,
3.3,
4, 6 to 9,
6 to 9.
and page 21 till the end, Your Lordship.
6 to 9. 6 to 9 is still the end.
6 to 9 and page 21. After that, I'll take Your Lordship to page 21, Your Lordship,
Page 21 of this judgment.
of this judgment. It's a lengthy judgment, so I'll just take Your Lordship to the relevant paragraph, Your Lordship. Here, advertisement was set aside, Your Lordship. 3.1.
3.1, yes.
Facts and circumstances as narrated in the writ petition are that the Manipur Technical University came to be established pursuant to the promulgation of the ordinance called the Manipur Technical University Ordinance, wide notification this. And in order to make the university functional, the registrar issued a notification. This can be read as advertisement for appointment to the post of assistant professor on contract basis in respect of some subject, including humanities, computer engineering, electrical engineering, mathematics, civil engineering, mechanical engineering. The petitioners were eligible, applied for appointment to the post of assistant professor. And after the interview having been held, the selection committee recommended the names of the petitioner for appointment to the post of assistant professor against the post shown as against their names. On the basis of the said recommendation, the petitioners were appointed on contract basis, wide order dated this, issued by the Vice Chancellor, and the contractual appointment was extended for 6 months or till The regular appointees join the said post, whichever was earlier, by order dated such issued by the VC. 3.3, para 3.3. To the petitioner's utter surprise and dismay, the university notified a fresh recruitment, that is advertisement, of all the posts of the university by notification dated this. And being aggrieved by it, the instant writ petition has been filed by the petitioners on the inter alia grounds that since the petitioners have been appointed after following the due procedure, their appointment was within the ambit, province, and scope of the provision of Article 16 of the Constitution of India, that in terms of the law laid down by the Honorable Supreme Court, the petitioner ought to have been provided with orders of regular appointment, and that the initial period of 2 years ought to have been treated as probation. 4. An affidavit of opposition on behalf of the respondent university has been filed, wherein it has been stated that the selection was done only by interview and not done in consonance with the procedure for regular appointment, and the engagement of the petitioner was done for a short period in order to start the university. May I take your lordship to para 6? Para 6. Relying upon various decisions of the Honorable Supreme Court, Sri such and such, the learned counsel appearing for some of the petitioners had made submission, one of which being that since the petitioners have been appointed after following due procedure, their appointment was within the ambit, province, and scope of the provision of Article 16 of the Constitution of India, and therefore, in terms of the law laid down by the Honorable Supreme Court, the petitioner ought to have been provided with orders of regular appointment, and the initial period of 2 years ought to have been treated as probation. In support of his contention, he placed reliance on the decision of the Honorable Supreme Court in UPSC versus Girish, wherein the Honorable Supreme Court held Article 16, which finds place in Part 3 of the Constitution, relating to fundamental rights, provides that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in public offices. The word employment or appointment cover not merely the initial appointment, but also other attributes of service like promotion and age of superannuation, etc. The appointment to any post under the state can only be made after a proper advertisement has been made, inviting application from eligible candidates and holding of selection by a body of experts or a specially constituted committee whose members are fair and impartial through a written examination or interview, or some other rational criteria for judging the intrinsic merit of candidates who have applied in response to the advertisement made. A regular appointment to a post under the state or union cannot be made without issuing advertisement in the prescribed manner, which may in some cases include inviting application from the employment exchange where eligible candidates get their name registered. Any regular appointment made on a post under the state or union without issuing advertisement, inviting application from various candidates and without holding a proper selection where all eligible candidates get a fair chance to compete will violate the guarantee enshrined under Article 16 of the Constitution. May I take your lordship to page 10. Second paragraph, starting from fifthly. Finally, it has also been submitted that at the time of advertisement being issued by the university, regular vacancies were available. In this case, your lordship, regular vacancies, sanction post, vacant post of AHS was available. The UGC regulation 2010 were already in operation, and the university could have initiated recruitment process for appointment on regular basis, which the university failed to do so, and therefore the petitioner could not be allowed to suffer for no fault of theirs. He has relied upon the decision of such and such, wherein the Honorable Supreme Court, accepting the contention of the learned counsel, appearing for the appellant that the appellant should not be made to suffer for no fault of hers, directed the appellant shall be treated as a regular student of BSc HSC Part 2 course of study, and the result of examination shall be declared forthwith. A similar view was taken by the Honorable Supreme Court in this. May I take your lordship now to para 7? So just read out the relevant portion. On the other hand, it has been submitted by Sri such and such advocate appearing for the respondent university that the appointment of the petitioner was purely on contract basis and as per the terms and conditions of the agreement and the undertaking given by them, they cannot claim for regular appointment at all. Just the stand taken in this case. In support of his contention, he has relied upon various decisions of the Honorable Supreme Court. The first decision being the one rendered in Secretary such and such, Your Worship. Now, may I take your lordship to para 8? Page 16. Para 8, your lordship, page 16. It is not in dispute that the university was established by notification dated this for the advancement and development of technical education and for connected matters. The registrar of the university issued notification dated this for contract engagement in respect of various subjects, and in response thereto, the petitioner applied for it. After the interview has been conducted, the selection committee recommended the names of the petitioner who were appointed on contract basis. May I take your lordship to the 5th line from the bottom, page 17. On 23/5.
Contract basis
Yes.
for a period of.
For a period of 6 months, whatever, just 10. May I take your lordship to the 5th line from the bottom, on 23/5. On 23/5/2018, the university issued a notice inviting application, there is an advertisement, from amongst the eligible persons for appointment to various posts, teaching and non-teaching, including the post held by the petitioner. This notice stated this is under challenge in this writ petition. Now, para 9, next page. The question, having regard to the facts and circumstances of the present case, is as to whether the petitioners are entitled for regular appointment. In order to decide this main issue, this court will be required to examine the ancillary issue. The first ancillary issue is as to whether the recruitment has been done by conforming to the provision of Article 16 of the Constitution of India. The answer ought to be in the affirmative, even in this present case, for the reason that while undertaking the selection process, the same has been done in accordance with the provision of Article 16 of the Constitution of India, which provides for equal opportunity and employment, in the sense that the advertisement was issued inviting application from amongst eligible candidates, that the interview was held by the selection committee, and that only on its recommendation the petitioner were appointed by the university. The second ancillary issue is as to whether the appointment was purely on contract basis, and since the petitioner having given undertaking that they will not claim for regularization, the writ petition is liable to be dismissed, the stand taken by the respondent. It is an undeniable fact that appointments were purely on contract basis, as is evident from the advertisement itself and the appointment orders issued by the university, and moreover, the petitioner have given the said undertaking. But the contention of the Learner Council appearing for the petitioner is that it was a mistake on the part of the university when it did not initiate recruitment process for regular appointment on regular basis, and therefore it cannot take advantage of it. His submission has merit and substance. The clear vacancies were admittedly available at the time when the advertisement was issued by the university. I have taken your lordship to that post creation. That was in 2006. I've been appointed in 2007. As per NCTE norms, 80% of the posts ought to have been filled up on regular basis, which the university failed to do so. However, the Learner Council appearing for the respondent university has heavily relied upon the decision rendered by the Honorable Supreme Court in Umadevi. Same here, to contend that the petitions are not entitled to be regularized at all. It is no doubt true that the Honorable Supreme Court has laid down the law as regards the constitutional mandate in matters relating to public employment, including the appointment on contract basis. But the decision in Umadevi case will have no application at all to the facts of the present case, for the reason that all that the Honorable Supreme Court has held in respect of contract appointment is that if the contract appointment has been met without following due process of law, it is without advertisement, they are not entitled to be regularized. This is not the case in the Not so in the present case, because due process of law has been duly followed, and there are many instances where the appointment on contract basis after following due process have been regularized by way of policy deviation. Now, may I take your lordship to page 21? Sixth line from the bottom. The learned counsels appearing for the petitioners have submitted that in terms of the decision rendered by Honorable Supreme Court in Arjun Singh, a direction ought to be issued to provide the petitioner with orders of regular appointment from the date of the initial appointment. The fact of that case was not exactly the same as that of the present case. But the background or the circumstances on which the Honorable Supreme Court has decided the matter may be relevant for this case as well. In that case, about 14 cases of assistant accounts officer were required to be filled up by HP Electricity Board on regular basis, and accordingly, it is requested that the state government to fill up the said post by direct recruitment on regular basis and send a requisition thereof to the Public Service Commission. The requisition was duly sent to the Public Service Commission. When the advertisement was issued by the Public Service Commission, the nature of appointment was shown to be contract basis. The applicant applied for the said post, and after they've been recommended by this thing, they were being recommended by the Public Service Commission, they were appointed on contract basis. This should have been on regular basis. The Honorable Supreme Court, while observing that the respondent failed to disclose the circumstances in which the advertisement was issued, showing the nature of appointment to be on contract basis, held that it is not a case of regularization of service of the applicant, but was a case where a direction ought to have been issued on the respondent to provide the applicant with order of regular appointment from the date of initial appointment, and to treat the initial period of 2 years as probation and to provide them with consequential benefits. The Honorable Supreme Court further held that such action on the part of the authorities not only amount to unfair employment practice, but also arbitrary and violative of Article 14 of the Constitution of India. In the present case, it is not disputed that at the time when the advertisement was issued, the vacant posts were available, Your Worship. And that sanctioned post, vacant posts of AHS were available. The vacant posts were available, and the university could have initiated a recruitment process for appointment on a regular basis, but it failed to do so for the reason best known to it. The recruitment process remained almost the same, except the determination of scores on academic records. Moreover, since the UGC Regulation 2010 were in operation, the university could have done the recruitment process in accordance with the said regulation if it really wished to do so. Failure to do so by the university in accordance with the UGC Regulation 2010 was due to its fault and cannot be attributed to the petitioner. Since the petitioner have already been subjected to recruitment process without the same being questioned by anyone, there is no need for them to undergo another recruitment process, Your Worship. In the particular facts and circumstances of the present case, this court is of the view that the petitioner cannot be denied appointment on regular basis for no fault on theirs, and that too after they've been subjected to long process of recruitment. In view of the above, and for the reasons stated here and above, the instant writ petition is allowed, and consequently, the notification, this is the advertisement, issued by the register in respect of petitioner is caused and set aside, with the direction that the university shall provide regular appointment to them from the date of the initial appointment. There shall be no order as to cause, Your Worship. Now, in my respectful submission, Your Worship, the petitioner is also appointed by a competent authority after going through a regular selection process. Therefore, the respondent ought to be directed to regularize the service of the petitioner, or, Your Worship, in the alternative, not to advertise the post till such time the service of the petitioner is adjusted against the post of horticulture specialist in terms of the letter of the Ministry of Agriculture, Your Worship. That is one. My second ground, Your Worship, is on legitimate expectation. Worship.
Mr. TB, the issue is that he was never appointed as horticulture.
Yes, I admit I was never appointed. I was appointed as consultant technical through a regular selection process. Your Worship.
That post is non-existent post.
That was not unexistent. Then when the post of assistant horticulture specialist was still there vacant, because the post was created in 2006, I was appointed in the year 2007. The post was there already, but
No, the post of that technical.
assistant horticulture specialist, it
that
was
was
there.
there.
But they have not done that.
It is a post in the department, it is a sanctioned post in the department.
It was
The
sanctioned post.
post against which you are appointed is not a sanctioned post.
There's no post. I'm admitting it. There's no post of consultant technical. So there was no post of consultant technical, but they have advertised the post. They have appointed me, but then they have adjusted me against the post of assistant horticulture specialist, which was a sanctioned post, vacant post. So the practice adopted by the respondent is not fair. It was not fair. When there was already a sanctioned vacant post of assistant horticulture specialist, Your Worship, but they have taken the other way around so as to deny me of this thing. Supposing if it is appointed as assistant horticulture specialist, then regular scale of pay has to be paid. Regularization has to be done. But then, in order to avoid that, I have been appointed as consultant technical on fixed pay.
You have accepted that.
I have accepted, but the manner in which it was done is not fair. And next ground, I am taking legitimate expectation. Why? Why on that ground, Your Worship?
Okay, let us.
Now, Your Lordship, the petitioner has been given legitimate expectation that his service will be absorbed both by words and also by conduct. And both by words, that is the letter, which is letter of the ministry, that is 12 December, Your Lordship, which I've already taken to. And how legitimate expectation is given to me by conduct, Your Lordship. For that, may I take Your Lordship to the affidavit in opposition. Affidavit in opposition, 38. By words, Your Lordship, there is letter dated 7 December 2011, and by conduct. Affidavit in opposition, may I take Your Lordship to the service rule. Page 41.
Again, the same issue.
Now, this is the old service rule of 2007. The first one which I've taken, Your Lordship, is the latest service rule 2022. Page 41. Lordship has got it. This is recruitment rules 2007. This is for Group B and Group C post. Group A, B, and C post. The earlier service rule which I have taken Your Lordship to relates to the post of assistant horticulture specialist.
Which is the service rule now which you're referring?
This is the service rule of 2007.
Which?
Page 41. This notification dated 19 March 2007. Lordship has got it. I'll take Your Lordship to the schedule, the table below. Next page, relevant page will be 42. The bottom table is number 3 is the post of assistant horticulture specialist. Lordship has got it.
This is still in existence.
This is the old rules. Why? No, it's already repealed, but why I'm coming to this, I will satisfy Your Lordship. Because as per this rule,
But Mr. TB, this refers to assistant horticulture specialist. I'm still not convinced.
But I, that is my case, Your Lordship. I leave it to Your Lordship. I've been always treated as assistant horticulture specialist, Your Lordship. Now, page 43, Your Lordship. Period of deputation, including short-term contract, the last portion. In another ex-cadre post, Lordship has got it. Page 43, right side column, the last paragraph of that column. Period of deputation, including short-term contract. Includes period of deputation, including such.
Why are you making that submission?
Why I'm making this submission? As per this, it maximum is 3 years. So my contract period cannot be extended beyond 3 years.
But your contract is not for this post.
Admitted, Your Lordship, but I've been always treated and I'm shown as their own documents. I'm not saying their own document is showing me as occupying the post of assistant horticulture specialist.
One letter.
And this is official. This is a record. It's a matter of record.
I'm saying,
Yes.
I'm saying whether that one letter can do away with the stipulation in the advertisement.
That I leave it to Your Lordship. That I leave it to Your Lordship. So as per the recruitment rules, Your Lordship, which was in force at that point in time, Your Lordship, the short-term contract period cannot be extended beyond a period of beyond 3 years. But my contract tenure has been extended from time to time, Your Lordship. And as I've said, I'm serving since the last 18 years.
CB, you have also not objected when your contract service as technical was extended.
No, I have, because I had legitimate expectation. I had legitimate expectation that I will be absorbed. So why, so Lordship, the question of objecting to my extension does not arise, Your Lordship. Well, when the recruitment rule says that short-term contract cannot be extended beyond period of 3 years, and I've been allowed to continue now for 18 years.
In that post.
In that post, Your Lordship, and which is not assistant horticulture specialist. My case is that I have been adjusted against that.
We're 42 or 43 page?
Page 43.
Officers of the holding 3 years experience in the where is that limit of 3 years?
Not exceed 3 years.
Where is that?
Period of deputation, including short-term contract. Lordship has got it. Just 5th line. Shall ordinarily not exceed 3 years. So my contractual service has been extended from time to time. Now now since 18 years I'm serving, and thereby legitimate expectation. This is by conduct, Your Lordship, and by words, Lordship. I've taken Your Lordship to the letter 7 December, where the ministry has written that I should continue as consultant technical or till I am adjusted against the post of horticulture specialist, Lordship. Now, on legitimate expectation, I'll just take Your Lordship to the case law only.
Yes.
1998, 7 SCC, the 3.
Oh.
Lordship has got it. This is by 3 judge bench. Para 18 to 23. Para 18, Lordship has got it. The doctrine of legitimate expectation has its genesis in the field of administrative law. The government and its department in administering the affairs of the country are expected to honor their statement of policy or intention and treat the citizen with full personal consideration without any iota of abuse of discretion, Your Lordship. The policy statement cannot be disregarded unfairly or applied selectively. Unfairness in the form of unreasonableness is akin to a violation of natural justice. It was in this context that the doctrine of legitimate expectation was evolved, which has today become a source of substantive as well as procedural right. But claims based on legitimate expectation have been held to require reliance on representation and resulting detriment to the claimant on the same way as claims based on promissory estoppel. I'll just take your lordship to para 23. Just the most relevant paragraph. This court further observed that as under the existence of legitimate expectation may have a number of different consequences, and one of such consequences is that the authority ought not to act to defeat the legitimate expectation without some overriding reason of public policy to justify its doing so. In a case of legitimate expectation, if the authority proposes to defend a person's legitimate expectation, it should afford him an opportunity to make representation in that manner, Your Worship. It may be indicated here that the doctrine of legitimate expectation imposes, in essence, a duty on public authority to act fairly by taking into consideration all relevant factors relating to such legitimate expectation. Within the conspectus of the fair dealing in case of legitimate expectation, the reasonable opportunities to make representation to parties likely to be affected by any change of consistent past policy come in, Your Worship. Here, Your Worship, no opportunity has been given to me. I was also not even heard, Your Worship. And then that advertisement has been made. Now, third, Lordship, on estoppel. My third ground, Your Worship.
Which is that citation?
On estoppel, Your Worship.
2008.
Lordship?
Is it 2008-14?
Yes, 2008-14.
On estoppel.
Yes, Lordship. No. On estoppel, I have not placed any case, Your Worship, but my case is that after giving legitimate expectation to the petitioner, both by words as well as by conduct, and when in my respectful submission, the RR provides for absorption of short-term contract employees, Your Worship, it is unfair and unjust on the part of the respondent authorities not to absorb or in the alternative to adjust the service of the petitioner, be it in the post of assistant horticulture specialist or horticulture specialist, and that too after utilizing his service for 18 long years, Your Worship. Therefore, the respondent authorities, they are now stopped from taking the stand that there is no provision under the recruitment rules, and more so when the recruitment rules provides otherwise, Your Worship. Now, regarding the case law, Your Worship, I place judgment passed by another high court, that is Honorable Manipur High Court, Your Worship, on that. May I take Your Worship too?
Yes.
Okay. Now, before that, Your Worship, I have the case law number 4 on legitimate expectation. I have just one paragraph. This is to 2023 5 SCC, para 29. Para 29.
Yes.
Yeah. A person is said to have a reasonable or legitimate expectation if a representation or a promise made by an authority. In this case, a representation has been made, either expressly or impliedly, both expressly by word and also by impliedly by extending my contractual appointment, gives room for such expectation in the normal course. While applying the doctrine of legitimate expectation, the primary consideration are reasonableness and fairness of the state action, Your Worship. Now, on judgment passed by another high court, Your Worship, I'll just refer to the last case law, 2008, 14 SCC 283.
It has a processor value.
Yes, Pradeep J. Mehta, last, para 23. Lordship has got it. Although the judgment referred to above were cited at the bar in the High Court, which were taken note of by the learned judge of the bench of the High Court, but without either recording its agreement or dissent, it answered the two questions referred to in its favor of the revenue or judicial decorum, propriety, and discipline required that the High Court should, especially in the event of its contra view or dissent, have discussed the aforesaid judgment of the different High Court and recorded its own reason for its contra view. We quite see the facts that the judgment given by High Court, this is relevant. We quite see that the facts that the judgment given by a High Court are not binding on the other High Courts, but all the same, they have persuasive value. Another High Court would be within its right to differ with the view taken by the other High Court, but in all fairness, the High Court should record its dissent with reason, therefore, Your Lordship. Now, coming to the second case, Your Lordship, the facts are same, my legal submission are same, Your Lordship. You just take the 10 minutes, Your Lordship. The second case is writ petition 39.
Why don't we differentiate it?
No,
By a different judgment?
By my submission will be the same, except for the facts that the difference is that here again, initially he was through selection process by way of advertisement, he was appointed as consultant technical. While serving as such, again the post of horticulture specialist was advertised. He applied, even the petitioner here applied, both of them. But since there was only one post, the petitioner in 39 was appointed as horticulture specialist. And the petitioner hearing has been kept in waiting list, except for that, Your Lordship. Otherwise, my submissions are the same. The objection? Selection is page 24. Result.
Subsequent selection?
Yes, for the post of horticulture specialist, page 24. The last para.
This is in Hindi.
No, Your Lordship, page 24, annexure 5.
Oh, page 24, annexure 9. This is.
No, WPC 39, writ petition, Your Lordship. Lordship must be going through that affidavit of my writ petition.
Page
24. Lordship has got it.
This is walk-in interview.
Yes. As per advertisement number such and such that appeared in the national as well as local newspaper, the walk-in interview, this is also advertisement, selection committee. Now, last para. The member scrutinized the biodata of all the candidates and they were interviewed by the committee. The following candidates were selected for the post of horticulture specialist. Selected Mr. Anjani Kumar Singh. The second waiting list, the petitioner in the earlier writ petition, Your Lordship.
This is on contract basis.
Yes.
Where does it say contract?
That first paragraph, purely on contractual basis, fourth line. As per advertisement such and such was conducted by selection for the post of horticulture specialist. Lordship has got it. And 25 is the appointment order. Contractual basis on fixed pay. So except for this, the facts are same. And my submissions are all same, Your Lordship. But here in this case, he was appointed through a regular selection process against a sanctioned vacant post of horticulture specialist.
Any citation for this?
No, the same case law I'm referring to, Your Lordship. I'm relying on the same legal submission, Your
So
Lordship.
the facts are a little different.
Except for that consultant technical, that is the thing. And as I've said, Your Lordship, both the petitioners, they have been serving for more than now 18 years. And going by the age, they have hardly 5 years of service left, Your Lordship. Now, since the upper age limit is 35, even if they want to participate in the of course, the advertisement that has not been given effect to, but if the post is advertised, they are not even eligible for applying for the said post, Your Lordship. Now, take into consideration the fact that they have sacrificed their prime youth. That is also on fixed pay, Your Lordship. They've been serving for 18 years, and after going through a regular selection process, Your Lordship. Now,
Suppose you are regularized.
Lordship,
Suppose.
Lordship.
Assuming.
Lordship.
What would be the financial implication? It will be huge
No,
unless notional is given.
that will be up to Your Lordship, Your Lordship. At least I may be allowed to continue till my remaining 5 years or 4 years.
On what basis?
Consider the fact that the same submission, Your Lordship, whether now, so far as the second writ petition is concerned, that is against sanction post, right? And that with effect from the date of the relief, if Your Lordship is giving relief, with effect from that, and notional whatever that can be done so far as scale P is concerned. And coming to the first writ petition, Your Lordship, now, at least some human consideration can be given, Your Lordship. It is not a backdoor.
How to continue on contract?
That, or at least it post should not be till I am adjusted against the post of horticulture specialist. Be it contracts, fixed pay, it's okay, Your Lordship. It's okay, it's acceptable to me. At least, but till my post is adjusted against horticulture specialist, may or may not be, since I have only 5 years left.
What about suppose if direction is given to allow you to serve on the contractual basis in the post of technical assistant?
The consultant technical, Your Lordship, the post is not there.
You are there. See, the issue is that you are in that post. That is the issue.
Okay, okay, Lordship, then I may be allowed to continue as that till such time, in terms of the letter 7 December of the ministry, till I am adjusted against the post of horticulture specialist. May happen, may not happen during my service career. Yeah, I have hardly 5 years left. That is my submission, Your Lordship.
Okay, Mr. Young.
Obliged, Lordship.
We hear you on Thursday. Mr. TB, kindly bring the advertisement.
Advertisement.
The first advertisement.
Lordship.
Are you aware about the date?
They have mentioned, Lordship. Oh,
Mr. Young, what you can produce?
their records are there with them.
The first advertisement, appointing them on a technical, this thing on contract.
I will try, Lordship.
Both of us will try, Lordship.
You don't have a copy in your possession?
That I'll have to inquire, Your Lordship. Without instruction, I cannot make that submission, but I'll also try from my side.
Had Mr. TB Jamil, the learned counsel for the petitioner, and Mr. Gauhati, the learned CGC, for
All the
all
response.
the respondents. Listed.
Monday, Your Worship. Your Thursday, we have one part of matter, but now
That's admission.
information. Look at the matter.
Yeah. That is in the admission list, no?
No, hearing.
No, that is admission hearing.
No, it was in hearing list. So that I get more time also for the Monday, Your Worship, if it is convenient.
Okay.
Yes,
Listed again. As a part of the item. On. On, yes. 21. On 21, 10, 2024. Stop. Both the learned counsel for the parties shall also make an endeavor to produce the first advertisement notice in terms of which the petitioners were appointed as technical.
as consultant, within bracket
as
technical.
Consultant within bracket technical on contract basis.
So Lordship, here, another problem is that the advertisement was published in both national paper and local paper. We may produce only one.
Anyone,
Only
because
one.
the content
Yes,
will be same.
yes,
Okay,
Lordship,
anyone.
Lordship.
Let's keep this, okay? Please and keep it. Okay, we'll end this one. Which is this? 38. This is 38. 38, okay. Take care of it, okay? Okay.
Obliged.
What else we have? Non-judicial system, green color, brown. Green, no, brown color. Green or brown.
Excluded gitu. Iya. Kita kudu part 3, 4, 5. Part pasta. लेकिन देख ले कल मिला डिस्पोजल नहीं है Ini cuma ada 6 copies na 6 14 10 practical 1 8 9 10 23 110 CPM to 3 Itu kok lagi di video jalan lagi. Lagi apa sih nah itu? Ini pembukaan baru. I'll send out an army to find you. Little of God. Dulu je. Dili sana. Kes yazı devi de. Bu değil aslında. Oluydu. Kes kum dili aslında oluydu de. Oh.